There we are. Okay. The October meeting of the California Law Revision Commission will come to order. Executive Director, would you call the roll?
Yes. Commissioner B?
Present.
Senator Blakespear indicated she would not be here. Commissioner Carrillo? Here. Commissioner Carrion?
Present.
Commissioner Kubas?
Present.
Commissioner Hebner?
Here.
Commissioner Jenkins?
Here.
Assembly Member Colbert indicated he would not be here. Commissioner King? He did indicate that he would be joining, but it looks like he has not joined us yet. And Commissioner, oh, sorry about that. So should I recall the roll? Okay, my apologies. Okay, I'm gonna call the roll again because apparently I did not have my microphone on. So B,
Present.
Carrillo?
Here.
Carrion?
Present.
Kubas?
Present.
Hebner?
Here.
Jenkins?
Here.
King is not present yet, and Simpson.
Yeah.
Thank you.
Very good. We will stand in brief recess for a private session on personnel matters with the Executive Director. We'll be back in 30 minutes. Back in session. Our second agenda item are the minutes of the August 15th hearing.
Move to adopt.
Excuse me?
Move to adopt.
Wait, are there any revisions or corrections? There's a motion. Is there a second? Is there any opposition? Motion passes. Administrative matters. Madam Executive Director, it's yours.
Yes. So we start with the report of the Executive Director. I'd like to let the commission know that we're almost done. Can you hear me? With our IT migration that we've been working on for many months. I think our last thing that we are taking care of is migrating our website away from UC Davis to GoDaddy. And I'd like to thank Deborah and Cara for all their hard work on this giant migration project over the past several months. The next thing I wanted to bring up is the budget. As you know, the state of California is facing a budget shortfall, and the legislature it chose to address it in a couple of fashions. One was eliminating vacant positions potentially, and the other is a across the board 7.95 cut to budgets. So far, we have not had any vacancies cut, and we do not believe that we will. So that is really good news. We have not received anything from the Department of Finance as far as instructions related to the 7.95% cut. That would be very difficult for the commission to absorb since we're such a small agency. So we will be working actively with the Department of Finance to keep any cuts to as minimal or zero as possible. And just to mention a goal for next year, I think, as you know, our office space is actually in the basement of the building that Legislative Council is in, and we're very grateful to Cara and her staff for working with us on that and giving us access to a conference room. But budget permitting, I think one of the goals for next year is to see if we can locate and rent our own office space, so we all have a place to come into. So that's it. Does anybody have any questions for me?
No.
Thank you. So the next item on the agenda is commissioner suggestions. Do we have any commissioner suggestions at this time?
Seems as though we have a full workload already. Is that your evaluation?
Yes, it is.
Then the absence of suggestions is probably welcome.
Okay, then the next thing we have on the agenda is new topics and priorities. And you all received a memo outlining this. It's our annual memo, basically listing where things are at, whether we've received any new assignments, whether there's any suspended studies, and are there any proposed new studies. I won't go into it in detail because I know you're all familiar with the work we are actively working on. We do have one study that we think is coming to a close. That's the landlord tenant terminology study, which is on the agenda for final approval today. We do have a new legislative assignment that the bill was enacted. It's AB 1906, and it's a study on removing the terms dependent adult and dependent person from the California codes. It looks to be a relatively straightforward study. So we look forward to doing that and recommend that the commission treat this study as a high priority since it's a legislative study, and that the commission staff make as much progress as it can in 2025, consistent with other demands on its resources. Let's see, and then we have a brief discussion on the suspended studies. And then we did receive a proposed new study from a constituent. It's related to probate and whether somebody who was never a trust beneficiary has standing to appear in a probate proceeding. It's all summarized in the memo. When staff looked at it, based on a Supreme Court opinion, which said they were not weighing in on that particular issue, it seems like it would be an issue that the commission could add that topic to the list of carryover items relating to the probate code for consideration when the commission priority workload eases. So I do need to take a roll call vote on that. Does anybody have any questions about it?
No.
Okay.
David, did you have a question?
Yeah, I mean, I'm not adverse to the study topic. My question would be, does the commission actually have time, given our other high
I'm
priorities?
sorry, I'm having trouble hearing you.
Yeah,
Is
do we
there
have time
time?
to do it?
At this time, no. We do have a sort of a list of carryover items relating to the probate code that we could add it to. If in the event we have resources available in the future.
But I think if we were to adopt or accept this new assignment, wouldn't that be, excuse me. My apologies. If we were to accept this assignment, wouldn't it also be that we would be able to prioritize our list? Because right now we're in a situation where we are obtaining new staff. We're going to have different resources, hopefully in a couple months. So I think to me, it's important to not push away the work that the legislature is giving to us, but to really highlight the need for more resources to do what the legislature is looking for us to complete. So do you think that it would be something that in the future, within this year, we may be able to tackle, or is that too speculative at this point because of the staffing issues?
I think it's pretty clear. It's not something we would be able to
Okay.
tackle this year. So if because it seemed to be an open issue and we do have this sort of list of things that might come up for probate if we ever get to look at it. I thought it was worth bringing to the commission's attention.
Hmm.
If you don't think it's a good thing to add to the list at this time, we could have a motion to that effect as well. It's really up to you.
In the past, how many times if you know this answer, and I know that this may not be an easy answer to know off the top of your head, but how many times has the commission not accepted a study?
Yeah, and my apologies. I do not
Yeah,
I do not know. I think that there's some consideration of whether something's really viable or not, but I mean, it could be adding something to our list that realistically is years away from having time to do.
Commissioner Carrillo?
I would move that we table this at least until next year. That accommodates Sochi's point about waiting until our staffing situation settles. Maybe we move through antitrust with lightning speed and we find that we don't have enough to do. So I don't want to say no to this project, more like, can we look at this a little bit down the road?
So then the motion would be to table this topic until next year.
Yeah, I think the motion would be to identify the 5 priorities on page 10 of the memo,
Okay.
to reactivate, if the commission agrees, the work on the emergency law as time permits, and to defer for future consideration
Okay,
this project. So it's 3-step motion.
That's my
Okay.
motion.
I like that motion.
Is that, oh, you're recording, so you caught that. Is there a commissioner who will make that motion?
That is my motion.
I
Is
will
there a
second.
second? Great. Is there any opposition? Motion passed.
Do we need to do a roll call?
Actually, we do need to
Yes.
do a roll call. That's a very good question because we have commissioners who are attending by teleconference.
Oh.
So let me bring up the
Okay.
roll call. I did say that at the beginning. So we have, sorry, I just need to get my roll call list. We have B,
Aye.
Carrillo,
Aye.
Kubas, I. Carry on,
Aye.
Hebner,
Aye.
King,
Aye.
Jenkins,
Aye.
and Simpson.
Aye.
And just for the record, we do now have Commissioner King in
Yes.
attendance. He wasn't right here at roll call, so we will note that.
Very good. Let's move to memo 42. meeting schedule.
Yes, meeting schedule. So let me turn to that. So this is pretty much the boilerplate meeting schedule memo. As you all know, we still have the ability to do hybrid or meetings where some members attend by teleconference. That authority will expire next year, but for now, we can do that.
So at the end of next year it
Yes,
expires.
yes, at the end of next year. And, it could be that there's legislation that extends it. In looking at the schedule for this year and some of the big topics we have, like antitrust and working with the chair, we thought it would be prudent to have less frequent meetings so that staff and our commissioners have time to really think through and study the issues in between meetings. So what we've come up with is a schedule of 5 meetings that are roughly 12 weeks apart. We recommend that we continue the in-person format. We will have a little challenge, I think, for the January meeting because this room will not be available because they're doing some renovations, but we had a number of other sites that we had looked at.
Okay.
So we'll be able to fill that. But, keeping in mind that there is the option if somebody really needs to, they can still attend by teleconference. I don't know if you wanted to talk about the specific dates. I'm sure everybody has had a chance to look at the memo. Yes.
I was going to ask about the January meeting. If it's not inconvenient for everybody else, would it be possible to push that to January 23rd?
January 9th to January 23rd.
Right. Only if it's not an inconvenience to anyone else. It'll make a difference whether I can attend or not.
Does that work for folks?
I also have a conflict on January 9th, so that would work better for me.
So yes.
Does anybody have a conflict on the 23rd? I really don't want to inconvenience anyone.
No.
Great.
It's best to have the people present.
Okay, so then I think we need a motion to adopt the schedule with the change of the January meeting to January 23rd.
So moved.
moved. And a second down there.
And then
So
I,
would you call the roll?
yes, I have to do the roll again, so. B,
Aye.
Rio.
Aye.
Carry on,
Aye.
Kubas,
Aye.
Hebner,
Aye.
Jenkins,
Aye.
King,
Aye.
and Simpson.
Aye.
Okay. So the next item on the agenda
Special order.
is, actually, we have the legislative program, I
Oh.
believe, which is only going to take a
Oh,
minute.
great, good. Sorry.
So the legislative program memo, you've seen it several times as we've moved through the session this year. The final update is that the AB 1906, which I already mentioned, which relates to removing the terms dependent adult and dependent person from the California codes, was enacted. The other one that would have given us work had fallen by the wayside, I believe, prior to the last meeting. So this is really just an informational item that we've already discussed. Any questions?
Hearing none. We have a couple of minutes until our special order time. Would there be an objection if we jumped forward to agenda item number 9 and dispensed with that? Hearing no objection, it is time for the election of officers for next year.
Sure, let me just turn to that memo.
Very good.
So I'm sure you all have seen this memo before. It basically summarizes what our handbook says about election of officers. And I think unless there's any questions, I will turn it over to the chair at this time to call for nominations or receive questions, comments.
Are there any questions about process? I would assume not. Well, then the floor is open. Is there a nomination for chair for next year?
I nominate Commissioner B.
Other nominations?
I nominate myself as chair.
Other nominations? Hearing none, we have 2 candidates. Is
Sorry, I didn't hear who the other candidate was.
Commissioner B.
So I think we probably have to take them one at a time.
Oh, yeah, office
far as the
one at a
vote,
time.
yeah.
Yeah, I'm only hesitating. What does what's the form of ballot that's required? I've never seen a contested election, so I don't know what the form of the ballot would be. Is it simply oral or is it written?
And does it require a quorum to get elected, or is it the majority of
believe
those present and voting?
Commissioner's B hand is raised.
Oh, sorry, Commissioner B,
Yes,
you're recognized.
thank you. I appreciate the nomination, but I feel like I'm pretty new to the commission still. So I would defer to the other commissioner who was nominated.
Okay, so
Then
Commissioner
it's
B.
unopposed.
I'm sorry?
Yes.
Then it's unopposed.
Yeah, then Commissioner B withdraws. So the nomination of Commissioner Sochi is unopposed. Congratulations.
So
I believe there has to be.
But
a
we still
motion.
need to
Yeah.
call the roll.
There would be a motion
And a second. We need a
So
second.
I accept my own nomination.
And I'll second.
Okay.
Okay.
Great.
Okay, so I'm going to call the roll for this one. B,
Aye.
Carrillo,
Aye.
Carry On,
Aye.
Kubas,
Aye.
Hebner,
Aye.
Jenkins,
Aye.
King,
Aye.
and Simpson.
Aye. Excellent. The floor is open for nominations for vice chair.
I nominate Commissioner B. Sorry, you go first.
I would like to nominate Commissioner Simpson.
Is there a second?
Second.
Are there any other nominations? Second
Okay.
Director, please call the roll.
For the chair, vice chair position, B,
Aye.
Carrillo,
Aye.
Carry On,
Aye.
Kubas,
Aye.
Hebner,
Aye.
Jenkins,
Aye.
King,
Aye.
Simpson.
Aye.
So I believe, Chair, that the tradition is that since you started the meeting, you will continue as chair throughout the meeting.
That seems wise.
Great.
Congratulations to our new officers for 2025. We look forward to wonderful things, including a unanimous vote in both houses of the legislature on your proposals, which you bring to us on the antitrust restructure. That will be the mark
That'll be the mark
of your success or failure next year.
And I must say, Chair Hubner, you have been a great leader for this commission this past year. There's been a lot of changes to the commission that required a nuanced approach, and you have taken that as your vice president. I did not have to do anything because you were so good at your job. So thank you so much for your leadership this past year, and big shoes to fit, but I've got heels, so it's okay.
Thank you very much. I
right.
appreciate that. Steve,
Yes, thank you. I was wondering if you might clarify the motion as to who is the chair from the conclusion of this meeting until the beginning of the meeting in January. It's possible that there could be matters that come up during that period of time.
yeah, the new officers technically take office immediately.
Yes.
But it is our practice to defer that switch until the end of the meeting we're in the middle of. So when I adjourn this meeting, I am functus officio.
Sounds rather ominous.
Yes.
Any other questions from the gallery? Hearing none, we still have a few minutes. Can we jump forward to landlord-tenant terminology?
Yes, please.
Sure.
Okay, let's move to that and then we'll be pretty much right on time.
All right, this is my memorandum, 2024-49, presenting a staff draft report on this study relating to landlord-tenant terminology. The draft report is identical except for technical changes to the draft tentative report that the commission previously approved for circulation and seeking a public comment. We received no public comment on the tentative report. So this is a final report, which we need a vote on for approval or revision. If there is a desire for some revision to this report, it is due to the legislature by December 31st. So that needs to be kept in mind as well. Certainly, if anyone has any questions or comments, I'm happy to field those.
Okay, the floor is open. Are there questions or comments for Steve on this?
If not, I will move approval. Good job.
Excellent. Is there a second?
Second.
Please call the roll.
All right. Commissioner B,
Aye.
Commissioner Carrion,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Kubas,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Aye.
All right, thank you.
Thank you,
I got it.
Steve. Well done.
Thank you.
Anything else?
I think for landlord tenant, that
That's
is
all
it,
for
correct,
this.
Steve? And so then, let's see, it is 10:59.
Yep.
Our special order of business begins at exactly 11.
Which it is now.
Perfect. So do we have our ASL translator?
We did a minute ago.
Sarah? You're working on it, okay.
ASL interpreter's here, my video's not able to turn on based on the host.
Hmm.
Okay.
Okay, thank you for joining us for the translation. It looks like we're all on board, our technical support. Okay, so Steve, I think that this is your item, so we can turn it over to you.
All right, thank you. So there are two memoranda on the agenda today from the study, which continues the commission's proposed recodification of a very lengthy chapter of the Health and Safety Code relating to toxics management. I'm sorry, can I ask the interpreter if I'm speaking in a pace that's fine?
You're fine.
There,
Good.
okay, thanks. For future reference for the commissioners and any other interested persons, now that we've resumed this study, you should be generally seeing two memos of this kind at each meeting at which this study is on the agenda. The first memorandum on today's agenda is memorandum 24-44, which presents a cumulative draft of recodification segments that the commission has previously provisionally approved for inclusion in a tentative recommendation in the study. This memo typically does not require any decisions from the commission, and this particular memo is not an exception to that rule. It's mainly intended to be a reference for commissioners and other interested persons to keep track of where we are in the study and to see where we are. Eventually, this cumulative draft will become the legislative portion of a proposed tentative recommendation once we get there. Does anyone have any questions or comments about the cumulative draft, which is attached to this memorandum?
None stated.
All right. The second memorandum, again, a type that you're likely to see on each future meeting agenda, if this study is on that agenda, presents a new set of proposed recodified provisions of existing code sections. And this memorandum does require a decision by the commission. The staff is seeking provisional approval to include these recodified provisions in a future tentative recommendation. So you have a draft, and this draft, as contrasted with the cumulative draft, shows the staff's proposed revisions to existing statutory language in strikeout and underscore, so you can see what we propose to revise. The only thing which is not shown are changes which are essential to the recodification process itself. For example, changing section numbers, but also we could, for example, if the existing code section had a segment that was designated as a paragraph and we made it into a subdivision, then that would be changed as well. There are staff notes after some of these sections. Those are primarily meant for public comment. We're going to try to start working more closely with DTSC. We haven't received a lot of comment from them, but I'm going to be more proactive about going forward here so we can see if we can't get some of these issues perhaps at least tentatively resolved. But for now, I mean, there's still plenty of time, obviously. And so when there are questions in a staff note, I will ask if they can offer input. And perhaps by the time we have another cumulative draft presented, there will be some resolution. And then there will be issues that I can present the commission with at that time. But for now, what's in this draft, if it's approved, provisionally approved for inclusion in the tentative recommendation, will just go into the cumulative draft that you would see at the next meeting. As we resolve these notes, we'll resolve them and then they'll come out or they will change or whatever. The material is pretty technical and the revisions though are pretty straightforward. So I'm not going to go through each of them, but again, I'm happy to answer any questions or field any comments.
Let me ask you a question, Steve. I've been through it and very good work. I see nothing though that seems controversial. Is there something you want to draw our attention to, or did I read it correctly that this is mostly technical?
It is mostly technical. You know, the study is non-substantive. We were directed to not make any substantive changes to existing law. Sometimes there is a borderline question. If you really get into the weeds, you could look at what looks to be a technical revision and conclude that this actually changes the law. And so we're trying hard not to do that. And we're going to talk to DTSC, the Department of Toxic Substances Control, make sure that that's their view as well. But yes, we believe that it is purely technical changes. We're just trying to make the sections more readable. In some cases, we've broken them down, very long sections. We've tried to break them down into individual sections, or we've taken very long paragraphs and made them into individual subdivisions. That's the nature of the changes here. And then there's also organizing the provisions in a way that hopefully reads in a way that people can make sense of.
Okay, so the motion,
Just a quick question. So this is one that you've done in collaboration with DTSC?
Well, no, I would say unfortunately not. I mean, certainly we send out the memo goes out to them, but there's not often a lot of time. And we need to get better. I need to get better with working with them. I think they're probably waiting for some signals. In the past, we have talked to them about some of the provisions that actually haven't yet been presented because they were particularly complicated. Provisions relating to enforcement, for example, we've had some discussions. But we're going to have to come up with a procedure whereby we perhaps get some of this input before, if we can, before we even present them here.
Okay.
Right now, the amount that we've presented will hopefully can be discussed, and what's in the cumulative draft, we'll be able to come back to you and say, we've now talked to DTSC and they're good with this, or they request the following changes, and here's a memo that sets out the changes, and then we'll have to look at individual provisions. Right now, we're trying to sort of build this out to some extent. We still have quite a ways to go. This is an incredibly long chapter in the existing health and safety code. So there's almost a sense of, by the time we get to a certain point in the recodification, it's going to be necessary to go back a little bit because the law will have changed or there will have been some new development or something like that. But we're trying to do the best we can to involve everyone before we end up coming to you.
Okay, I just wanted to see where in the process this was. So
Right.
this will be go to and be available to DTSC staff to take a look at and see if they have any
Oh,
questions.
yes, they're certainly,
okay.
on our distribution list, and Yeah.
And just to clarify that, we have talked about it, and my direction is that we do affirmatively reach out
Mhm.
to the department to, because they're obviously an important stakeholder in this, and I think the sooner we know if they're seeing issues, the better.
Good, okay, thank you.
Very good. Oh, I'm sorry, please, Commissioner.
So I just had a question as with regard to some of your notes that were questioning some of the definitions that are involved in the cumulative draft. And I thought it would be appropriate to go back to DTSC to ask them their opinion, but I think I do have some concerns that, how it's interpreted might actually result in a substantive change. So how do you handle that when you're working on the draft?
well, it's not, I don't know that the definitional issues are necessarily different from any other change we make where there could be an interpretation that somehow is the substantive change. We're doing our best to avoid it. If there's are there any specific issues that you could give me an example of? It might help for me to be able to know what to talk to them about.
There's one, I don't remember if I marked it, but it was something, it had to do with the fact that there were, in 60075,
Okay.
your note, you made a note that there's some federal regulations and definitions, and it's unclear which would apply. And so I think the recommendation that was made was perhaps including some language that would say something to the effect of unless the context requires otherwise. And it made me a little bit nervous that would be a substantive change.
All right. Are you able to, if you're looking at the draft, can you tell me page and line number possibly?
Yes,
where I can
so
see?
in the cumulative draft, the first memo, on page 7, it's line 31, where it says at a minimum, it seems worthwhile to consider whether subdivision B should expressly limit the application of federal definitions.
Right. So, okay. So the bolded sort of question line there says the commission welcomes comment on the above issues, and that would be one of the issues. And so I will make sure to discuss that issue with DTSC, and perhaps we'll talk about it further. Obviously, this is in your domain as well, and so I guess we'll see. But thank you for pointing that out.
Sure. Thank you.
Any other questions? Comments?
Right. And I guess we haven't asked, I don't know if perhaps the person who needs or one of the interpreter, I don't know if that person is on the line or whatever, or is available, perhaps has some question or something. And I don't know if there's anybody else. Obviously, there's no one in the room, but maybe there's somebody, is there a way to tell whether people are watching or listening to this?
I believe the person who requested is watching, but there are no hands raised.
Okay. All right, then, unless we did this already, can I request a motion to did we already provisionally approve this draft for
So
inclusion?
I think we should see if there's any public comment.
Yes, that's the next step. Is there anybody waiting to comment online?
Right, that's what I was just asking for. I'm sorry. Is there any hand raised to indicate?
Yes. The hand raised now.
Hi,
Hello,
I
Blue?
saw that people were asking about the translation if I was listening. And I am here. I see the interpreter and I am following. Thank you for checking on me.
Thank you.
So did the commenter introduce themselves? We could hear a comment.
No, the commenter did not introduce themselves. Would you like me to announce who it was?
Sure.
Okay. The commenter was Blue Aldrich.
Okay. Thank you.
Is there any other public comment on this project?
It does not appear so.
Hearing none, the motion,
Actually, I do have a,
go ahead.
going back to Commissioner Jenkins' point. Just to go back to Commissioner Jenkins' point, as she highlighted this section. And as I reread it here and with analysis provided by Commissioner Jenkins, the thought that comes to me, it seems like the statement here is more of an analysis of a law versus as it's an opinion and analysis of a law in that statement versus the other statements are, this is how it's defined in federal law, right? So I think the difference in the notes is not providing, it seems like that would be an internal staff analysis that would not need to be included in the notes because the notes are generally used to prove legislative intent. Right. And that's really where the notes there may be an interpretation for substantive. So I just wanted to highlight just a,
So I should perhaps clarify.
Okay.
Because we've been doing this study for a while, and so
Yeah.
it may be that this is not fresh anymore. These notes eventually are going to go away. They're not going to be part of a permanent record. The only thing that once the commission submits a recommended recodification to the legislature, there won't, those notes, I mean, those notes are
They're not going to be added to the comments
to be added.
in any
for
way.
those to be
Okay.
added. I mean, it could be that it could be of some help to individual legislators who are looking at it, but it's typically our practice is I mean, they will, there's so many of these notes, I can't say with
Yes.
absolute certainty, but I just want to make sure that everyone understands that certainly many of these notes will no longer be there. The only notes would be things that perhaps were essential for the legislature to understand why we recodified the way we did. And certainly what's published in like West or Deering's does not include those notes.
Yes.
We just have a commission comment which follows if the recommendation is enacted. So
Right. But as a lawyer myself, I would, if I'm looking at legislative intent, I'm looking at all of it, which includes the drafts of this and the memo, which are available online.
Sure.
So I think that I wanted just to highlight, I appreciate Commissioner Jenkins raising the point, and I see the value in taking a closer look at these kinds of statements.
Great, thank you. I appreciate that.
Any other comments or questions? The motion that's being sought is to provisionally approve the proposed legislation in memo 45 for inclusion in a future tentative recommendation. And what that means is we're just approving, moving it forward toward it coming back to us for another approval at a later date.
Yes, in a document that will be more formal in nature.
Correct.
But still subject to being changed, yes.
Is there a mover? Is there a second?
Second.
Please call the roll.
Commissioner B,
Aye.
Commissioner Carrion,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Kubas,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Aye.
Thank you.
Thank you.
All right. Thank you
Very good.
much.
We're moving on to agenda item number 6, another special order, the antitrust study.
Yes, so I will try to keep the opening remarks fairly brief because I know we have a lot to go to, but I would point you to memorandum 2024-46. And what we've attempted to do with this memo is we've gone back through all the expert reports, all the public comments, all the transcripts of meetings, transcripts of public comment, and tried that we've received so far, not obviously at this meeting, and tried to assimilate them into a document that summarizes them, and the framework is the enabling legislation, ACR 95 and the things that the commission was directed to study. So if you look at we have a sort of a table of contents. It goes over the working group reports, educational sections, the competition journal, public comments, and then the thing that is of importance for the commissioners to focus is on the summary of recommendations. And as you'll see in the memo, we kind of use that term loosely because the commission is the one that's going to ultimately make any recommendations to the legislature, positions and options. So the big quick picture questions are, should California revise its antitrust laws? Should California have its own law on single firm conduct? Should California have specific antitrust laws for technology contact companies? Should California adopt an abuse of dominance standards? Should California have its own merger laws and other suggested changes? So in January, our intent is to come back to the commission with a real plan of how to tackle this. You know, the first year, the commission was focused on education and heard a series of wonderful lectures. This year, we've received, today we will have received our 8th expert working report analyzing the various issues that are under the antitrust umbrella. We've received over 1,000 pages of public comment from a wide range of organizations. We're very happy with that. We always welcome more. And so somehow, and I have to give Sarah and Cheryl credit for this, somehow they were able to put together a 26 page document that pulls everything together. And one thing that I want to give Sarah an opportunity to do is she has actually developed a database. And if you have looked at the memo and clicked on things, you will see it will often bring you to a database. And so I'm going to turn it over to Sarah. She's our database expert, and she's going to give you just a real brief run of how this all works.
Thank you. And Sarah, before you start that, just a couple of general comments, although we don't have our usual complement in the audience. It's important for people to understand that what we did this year on antitrust was an educational exercise. It was simply briefing from a diversity of people who are generally considered experts in the field. But we did not delegate anything to the experts except to ask them to give us their views on a variety of issues. So there was no delegation to the experts, whether that be drafting or decision-making. It will be the commission that in the coming year wrestles with everything we've heard and then attempts to identify the points that should be considered for potential revision or not. And apart from there being no delegation, the commission did not select experts with an outcome-focused view. In fact, the commission itself had no role in the selection of the experts. That was a staff function. Finally, I would say we're very focused on transparency going forward. After today, we'll be finished generally with the educational piece. And then the commission next year will begin its deliberations. We would like everything we do to be fully visible. And that's why our staff team has very quickly organized everything that's already been produced so that it is available to the public completely and is searchable. So it will be of value, not only to the commissioners, but to members of the public who are interested themselves. And with that introduction, please give us more information about the database. I myself have not yet gone into it, so I'd like to hear what it's about.
Certainly. Thank you, Chair. May I also dismiss our translator, Dale Cates?
There's been no request for a translator for antitrust, has there?
No.
Okay. Thank you, Dale.
Thank you.
Excellent. I'm going to share my screen and I'll walk you through how to reach the database through the CLRC website. Of course, as Sharon mentioned, you can go to the individual documents linked within the document and the footnotes directly. So, yeah. Okay. So we have linked the database to the, oops, let's see, I'm having trouble navigating. To the public comment index on the homepage for the antitrust study. So if you click on the public comment page, we have continued to update this index as well as updates the database that was mentioned. This index is strictly the public comments. So this does not include the expert presentations or some of the more in-depth research reports provided. From this link, this will take you to a. Mhm.
Sarah, where would the reports be found? They're also available on this page, aren't they?
They are,
But
yes.
just in a different section.
Exactly. So this will be within the antitrust document spreadsheet. So on here, you
Thank you.
can find 3 different tabs. The first, you'll find the expert reports and presentations. We've also done transcripts of the presentations and as well as responses to the panelists' transcripts and the exchanges that followed. On the second tab, you'll find a list of all of the public comments. They're listed by date and by the organization. For those who represented them, who were individuals in their capacities, those are listed under individuals. If they were sponsored by any groups, those are listed in the 3rd column to the right. And again, you can find their presentations and transcripts as well. So you'll find here public commenters who did not otherwise submit written comments. On the 3rd tab, you'll find the presentations that were presented primarily last year in the general overview of antitrust. Here you'll find links to our YouTube channel where you can review the presentations again. Also, there are transcripts that are going to be available. We have some excellent interns from UCSF Law School working on those. And further, if you would like to search something within, I've made all the files available, so you can click on them individually and access the individual presentations this way, and you can do a search for certain keywords if you're looking to find something in particular. And as always, if you have any questions, feel free to give me a call or shoot me an email. Does anyone have any questions about? Thank you. Thank you.
I think as the incoming chair for next year, this is going to be valuable for all of us to revisit some of the points. There's been a wealth of information and expertise presented, and it will be very helpful to the commission in its work and to ensure that the public does have an opportunity to see that their voices are being heard and recognized. Thank you.
Absolutely. You're welcome.
Now, Sarah, and I apologize, you might have covered this. Is the entire collection of data searchable by words and phrases? So if one wanted to identify abusive dominance, could one type abusive dominance and then see wherever that was mentioned throughout the different folders?
Yes.
Okay. Thank you.
Can you give us an example of that?
Sure thing.
We all may be at different tech levels here.
No problem. And let's see here. I'm only hesitating because I accidentally logged into the wrong Gmail account, so I don't want to accidentally show you my Christmas card list. So.
What about in the far left underneath the icon, there's a search button.
Let's see here. Let me get back to our original page here. There we go. Okay. So I'll walk you through again. Okay, so if you search in this drive, let's see here, and okay, so here you'll find, these are all of the documents that mention that phrase antitrust. So you can go through and you could click on, let's see, for example, the multi-party document here. This will bring you to this document that lists. And within this text, there will be the phrase antitrust study.
Thank you.
Helpful? Sure. Great. Any further questions? And I'm available for my limited availability for tech support on this as well.
Thank you. A tremendous amount of work. It's going to be very valuable both to the commission and to members of the public. I would also say if you're ever curious, if any member of the public is ever curious about what commissioners have said and not said, we do maintain the recordings of our meetings on the website, correct?
Absolutely.
How long are those preserved? They don't go away after a couple of years, right?
No, I've personally watched the last 4 or 5 years, so there's
Oh, good
quite a
heavens.
bit on there. So.
Okay, thank you.
Okay, unless commissioners have any questions about the memo or the database, I think we're ready to move on to the next order of business.
Yes.
Okay, so next up, we have Abiel Garcia and Diana Moss appearing via Zoom. As the process went on, we realized that it would be important to have an expert report on artificial intelligence and how that is working in the world of antitrust. So we recruited some of our experts from various committees or expert working groups. And Abiel and Diana should be available now to present their slides and their report. Thank you. We ready, Sarah?
Abiel, are you ready?
Yep.
Great.
Fantastic. Good morning, everyone. How's everyone doing today? Unfortunately, I think Diana had to jump off for a scheduling conflict at this time. But
Mr. Garcia, Mr. Garcia, we're having a hard time hearing you. Do you speak up a little bit or directly into the mic?
Let me see if I can switch mics and this might be better.
That's already better.
Okay, perfect. I'll stay a little closer then. So good morning, everyone. Diana had, I think, a scheduling conflict at this time, so I should be able to answer all the questions. The working group consisted of myself. I'm a partner at Kesselman Brantley Stockinger. I deal with antitrust matters mostly 90% of the time, both in compliance, litigation, consulting, and merger defense work. My partner, David Kesselman, is also on this committee, doing the same work as well. Also on the committee was Sam Miller, Diana Moss, and Fiona Scott Morton. Sam Miller is an adjunct professor at the University of California, College of Law, San Francisco. Diana Moss is the Vice President and Director of Competition Policy for the Progressive Policy Institute, and Fiona Scott Morton is a professor of economics at Yale School of Management. Can we go to the next slide, please? So the goal here of the report is really focused on AI and competition. Right now, just kind of in the news and in reporting, you hear a lot about AI and privacy concerns, AI and innovation. So our focus really here is on AI and competition. We started off with the idea of a digital ecosystem. So a digital ecosystem is a business model that features a platform, cloud technology, and a variety of applications, plus its users all connected as one digital ecosystem. And I should say, if at any point there are any questions, feel free to jump in and ask. these ecosystems online grow through acquisition rather than organic growth, right? So they acquire new entities. There are always, caveats to every rule, but through the majority, they grow through acquisition. The massive size, expertise, and scale tend to give them a bit of a head start with respect to AI and AI development. So they're already on the forefront, and I believe OpenAI is presenting later today, and there will be a slide in their presentation that kind of shows the different levels of what AI built. So I believe for reference, it'll be in the second supplement, exhibit 118 or page 118, page 8. Will show you the different levels of AI. So the application format, so what we know basically is ChatGPT. Then there is the large language model. Then there is the compute part of it, and then there are the chips, right? So all of this together work to create AI. For our purposes, we are focused on competition within creating AI, and then competition between companies that are using AI products, right? So we've identified 3 areas worthy of discussion: algorithmic collusion, unilateral conduct, and consolidation in markets where AI plays a significant role. Again, either in the development of an AI product or the use of an AI product. And we want to caveat that, as good experts should, we cannot come to a working consensus, but have a lot of opinions and diversity of thought. So we put in the report policy considerations and legal frameworks that we think would be important for the commission to consider. Now, the reason we're focusing on AI right now is the latest wave of growth and expansion within the digital ecosystems, right? And so that's why we think looking at AI now is very important to try and get ahead of any potential problems. Can we go to the next slide? So the first area we have targeted is algorithmic collusion. This is the one that has generated the most reporting in the legal world currently. I think the case that everyone has been talking about currently is the RealPage case. So RealPage, for those who are not in the legal sphere and following this day to day, a lot of landlords are using RealPage's revenue management software to essentially take their pricing recommendations on what an apartment should go out for rent. The problem, as alleged by DOJ and by multiple plaintiffs, is that RealPage's software was using confidential information, sensitive pricing data, up-to-date, up-to-date vacancy reports to then make pricing recommendations to each landlord. And then the landlord would be, DOJ would say, heavily pushed to accept that type of pricing recommendation, right? And the key here is that the algorithm was looking at competitor information that normally would not be shared in usual circumstances, right? There are a lot of other cases underway in such industries as hospitality and healthcare, where algorithmic software has been alleged to enable price fixing among competitors. And RealPage, the judges found that there was enough in the complaints to get past the motion dismissed, and those are moving to the discovery phase. A lot of other cases are underway, haven't been ruled on. There has been a ruling out of I believe a case based out of New Jersey and Atlantic City just recently. And the case there, the finding was that actually they could not move past the motion to dismiss, meaning the case could not go forward because there were no allegations that the algorithmic software, the AI that was making pricing recommendations, was using competitively sensitive information. So under the current federal framework, sharing competitor information that is normally private, so up-to-date pricing that isn't public, up-to-date either output reports, vacancy reports, information that generally a company would keep secret. If you're sharing that amongst competitors, that can be an independent violation of Section 1 of the Sherman Act. What the AI models allowed to do was essentially hide that feature and say, well, we're just looking at data. Well, what is that data? And so the distinction we're seeing playing out in the courts right now is, was the AI or language model or algorithm looking at competitively sensitive information that normally wouldn't be shared amongst competitors? Or was the model looking at aggregated data that would be otherwise okay under the eyes of the antitrust law to share amongst competitors? So these are all moving in different industries. There's some in the healthcare industry and, like I said, the hospitality industry. With regards to algorithmic pricing specifically, there have been some legislative developments So Senator Amy Klobuchar introduced the Preventing Algorithmic Collusion Act of 2024. This is not really based in antitrust and competition, but rather transparency. It demands greater transparency by requiring businesses to disclose information concerning the use of pricing algorithms, and then prohibit companies from actually using non-public competitor data to train a pricing algorithm. In July of 2024, the San Francisco Board of Supervisors enacted a first citywide prohibition on the use of algorithmic pricing to set rent. So that was just a flat reaction to kind of RealPage. So this area will tend to develop and grow over the next couple of years as these cases are becoming more and more popular, and a lot more products are being introduced into the marketplace to use AI, large language models, algorithmic pricing and data analytics to try and set optimized pricing levels. So here for the report, the working group kind of went back and forth on different positions on how the commission could look at different ways to help this specific issue. And so in our working group report, right, there are a couple different recommendations. One of them could be consider declaring that the concerted action requirement to the Cartwright Act. So the Cartwright Act requires two players to have concerted action. That phrase, specifically concerted action, would encompass multiple competitors that all know and use the same revenue management software or same program, understanding that algorithmic pricing is being used on their data to set prices, right? Because the key here, I think, if you look at the cases, is the allegations that a lot of the landlords, especially if you look at for instance, the Department of Justice case in RealPage, they make allegations that the landlords, so the users of the software, knew to an extent what was going on, and that the data being used wasn't generally public. And in the other cases, so for instance, the case out of Atlantic City, it looks like the data that was not alleged. And so that distinction, right, is easier once if you know, but if you don't know and the information is with the software company, it could be hard for anyone to uncover that that's what's going on. There's a couple other recommendations. The other one I'll mention outright is that the legislature could find under the Cartwright Act that an agreement amongst competitors to fix the starting point of prices is per se unlawful. So this, when we were talking in big tech working group, and I think in the single working group, the single firm conduct working group, the shifting of burdens. So by saying that if you fix the starting point of a price, even though you might all end up at different pricing, is per se unlawful, it acts as a burden shifting between plaintiffs and defendants to try and see get to who has the evidence that could show whether or not this is true. So we'll go to the next slide. So here, restrictive unilateral conduct that relies on or deploys AI. This is more of a forewarning of a section. So right now, as is mentioned in the report, there hasn't been any cases about a single firm monopolist using AI in an anti-competitive way. And I'm talking about using AI to engage in self-preferencing. Preferencing its own products over somebody else's, using AI to identify, what pricing should be at the exact moment that someone is looking at it, or using AI to set prices in such a way that are predatory, exclusionary, or discriminatory. We haven't seen any reporting of that. We haven't seen any others, but we wanted to include this section because AI, again, is just a tool, right? AI is a tool used by companies to try and better their products and ultimately help consumers, but it can be used maliciously, right? And so our concern is just, AI could be used to try and obfuscate or hide anti-competitive behavior that normally previously would have been maybe harder to do, right? So for instance, I'll go back to the algorithmic pricing situation. There would be emails between competitors if you were exchanging sensitive pricing information. Well, if I use software that is controlled at a central hub, it's a little bit harder for me to connect the dots, right? And so in my view, and I'll personally speak here for RealPage, it's what's called a hub and spoke conspiracy. So there's a central hub that collects all the data, and then the spokes go out to each individual user and you make a wheel. And that's how you connect the conspiracy to price fix. AI could just be used to make that harder. I believe there was a case recently that did not get past the motion to dismiss, and the judge said, there wasn't enough information allegations to connect all the different players together. So the rim of the wheel was not there. And again, this is just for us, an example of how AI could make it harder to detect anti-competitive conduct. So this section really is more of a warning and forewarning to just say, something that we should keep an eye on. And if the commission wants to be kind of forward-looking on this, we did have a pretty decent consensus about looking at the single firm conduct working group and adopting a lot of the suggestions that they had, which would significantly strengthen California law and make it more effective than the federal antitrust law in governing unilateral conduct. And again, this would be going to not protecting startups and innovators, while at the same time trying to further step away from entrenched monopolists who innovated, but then used their power to try and erect barriers to competition once they are, successful. Next slide, please. And then, so for the third point, we're going to kind of touch on consolidation involving cloud and AI. And I think this is the area that a lot of people have been discussing recently, whether in the news or in the industry itself, right? So again, I'll reference the OpenAI slide about who the major players are. There's only a handful at each level of the chain that is necessary to create an AI product. And so here, I think we do think there is a need to monitor the situation and understand how these partnerships are working between Microsoft and OpenAI or Apple and other players, right? And just understanding the sheer size of these companies and making sure that they're not stifling either innovation or creativity when it comes to smaller players in the space. Cloud computing, especially, something that I don't know if the commission has spoken a lot about recently, but it's deeply connected to AI because you need the power to create these large language models to teach them, train them, and to house data and stop computing power. And so this market is expected to grow significantly, and there are just three dominant services really, which is Amazon Web Services, Microsoft Azure, and Google Cloud, right? And so again, mergers and acquisitions in the tech space have historically been, at least I will say, in my personal view, underreported because they're under the HSR threshold, but also just we haven't kept a close eye on them. And so a lot of companies have acquired what, in my view, would be problematic positions that were just not looked at carefully enough. And so we advise the commission to think about, in terms of the mergers here in this aspect, to keep a close eye on it and try to create some policy for the legislature to be able to monitor not only mergers and acquisitions, but partnerships. I believe the Federal Trade Commission is currently looking at a couple of joint venture partnerships between different players in the market. And so again, the suggestion here would be something to give California antitrust enforcers a way to closely monitor cloud and AI markets from strategic either consolidation, strategic partnerships that close out other players, either that be through early information gathering, through filing an HSR with the FTC and DOJ, as well as the California Attorney General's office. Again, these are all different proposals that are within the working group report. Next slide, please. And finally, the idea of a California digital regulator. This is where the group did not have a consensus on, but again, wanted to put forth proposals to the commission, and following a more European style approach, where a digital regulator that could be housed either within the Attorney General or its own kind of office that would look at AI and tech generally from a more European perspective. And again, we've heard the abuse of dominance standard has come up multiple times in these hearings. And so the report kind of walks through the possibility of creating a California specific regulatory regime for the digital sector, what it would be based on, and what kind of the goals would be for that regulator. So regulate existing platforms to promote competition within the platform. For those who have not been following closely, the Epic Google and the Google search cases, right? Opening up these larger companies to allow competition within their digital ecosystems from third parties. And then also have the regulator look forward and regulate to minimize future anti-competitive conduct to allow for competition. So again, allowing, as we move into AI and products that are going to have AI built into it, trying to think ahead to make sure that those who have significant market power that have achieved it through anti-competitive means don't re-entrench themselves in new markets. So that's all I had. I was, short and brief. Again, I'm open to questions, happy to answer anything that I can and find an answer to things that I can't answer.
Thank you. Are there questions from commissioners?
Just, in this case, AI is a tool that firms could use to engage in anti-competitive behavior is really the sort of gist of this?
Yes, so I would say there's two ways to look at this. We'll step outside of the merger context for now, just because in merger, right, there's the different parts of how to create an AI product. But yes, if you're looking at, say, if I'm a hospital, I'm a dominant hospital and I want to figure out the most optimal way to raise my prices, I could use an AI tool to try and raise prices in a way that maybe the AI recognizes, well, I have market power because I'm the only one around and I'm going to jack up prices to bring it, because no one else can do anything about it, right? It'd be harder to monitor that and how that's working.
Okay. Thank you.
Not a problem.
Mr. Garcia, are you aware of any jurisdiction that has actually drafted or passed legislation related to the topic you've just presented on?
So there has been some drafting of language on just on AI generally in the EU. Now, we went back and forth as a working group, I believe, about whether or not that actually addressed the specific issue that we looked at, which is AI and competition. And in my view, I have not seen any language that specifically addresses that issue.
Okay, thank you. Commissioner?
Thank you for your interesting report. My question was whether you feel like the array of possible changes to antitrust law that the commission is considering in general, not specific to AI, whether you feel like the commission should be considering an array of potential changes that are specific to AI, or if to a greater extent, the problems that you identify would be adequately addressed if the commission winds up taking up some of the more general antitrust reforms that are on the table. Yeah, so I noticed, for example, that you specifically flagged for us that your working group did not come to consensus on a slate of recommendations, except for in one particular area. So, so that's concerning. If your answer is yes, you do need to be considering a specific subset or slate of AI reforms, then the next thing that's going to happen is we're probably going to kick it back to you and say, well, what would you do?
Yeah, that's a great question. That is a very good question. And I know if you ask, 7 different people, you'll probably get 7 different answers. In my view, as someone who's worked on big tech, the big tech working group, and has also worked on the AI working group, and has worked in the field for over a decade, my view is that there should be a larger view of if the commission is going to recommend changing laws in California, the antitrust laws in California, it should take a broader approach than just focusing on big tech and AI. And the reason for that is these are the issues of today, but they might not be the issues of tomorrow. And as a practitioner who regularly goes to court and goes through discovery battles and and as a practitioner who does both plaintiff and defense side work, bringing these cases is expensive on both sides, whether you're the plaintiff or the defense side, right? And on the plaintiff side, you're usually a lack of information. And so the laws have evolved in such a way that it's extremely hard to bring an antitrust case nowadays on the plaintiff side. So I think in my personal view, if this commission looked at seriously the report of the single firm conduct working group and seriously considered burden shifting to some extent on having access either through discovery mechanisms, or saying certain things are off limits, or if you can prove certain things, you can immediately go to discovery. That would take care of a lot of the problems we're seeing with AI and monopolists and not just in tech, but in healthcare, with the PBMs, or in a variety of other industries. So my rambling a little bit, but the answer to that question is, I believe the focus on single firm working conduct, and I think there are specific changes you can make to federal law that would take care of, or at least address a lot of the issues between big tech and AI. I think being industry specific just turns it into regulation, which creates a whole host of other problems, which you're going to need specific industry experts to look at it and keep evolving with it.
Okay. So what I'm hearing, I mean, one way to look at this is that antitrust in general involves, at its core, a fairly philosophical set of questions about who is intended to be protected, who is intended to be benefited. Is this about protecting competition? Is this about protecting the little guy, et cetera? What's the threshold for dominance? And so it sounds like resolving those fundamental philosophical questions in general would encompass the problems that you're seeing in AI specifically.
Yes, I hesitate to say a resounding yes on that, just because AI can evolve so fast and it's such a just open-ended idea of what it could be. But I would say yes. I mean, to me, I think a good way to bring it back to reality. So Judge Donato recently issued an opinion against Google, talking about how, look, Google had an early mover advantage, but it doesn't get to re-entrench itself in other areas just because of its size, right? It becomes big and then says, well, I don't want to compete anymore. I think, to me, the crucial aspects of competition are allowing free competition reign, right? So the California Supreme Court has specifically said in CIPRO, you're not allowed to buy your way out of competing, right? So that, to me, one, is a core principle that I think takes into account a lot of what we're seeing today. And two is consumer choice, allowing consumers to make the choice for themselves, rather than being forced or steered to have a specific search engine, to have a specific type of music player, allowing the consumer to make the choice on the platform that they choose. I think those are the two core tenets that, if it could be resolved by rewriting our antitrust laws in California, I think it'd take care of a lot of the issues that have been identified in this report and in others. And again, I say that personally speaking, but
thank you.
Yeah.
Anything else, Commissioner? Commissioner B, the floor is yours.
Thank you. Thank you for the excellent report. My question is, in terms of unilateral conduct, the group indicated that adopting the single firm working group's proposals would help in that situation. So as there are new innovations that maybe we can't even imagine today, would the single firm proposals, which I assume include the burden shifting, would those address future innovations and future AI stuff that we can't think of right now?
So let me go back to look at the working group where I read it yesterday, but my answer is yes. It is forward looking and builds into the idea that there are things we potentially cannot even dream of to this day. That hopefully through this burden shifting, through the framework that has been proposed, would allow enough flexibility in the proposals that the single firm working group did, would allow flexibility to bring future actions that address future issues that we haven't even thought of.
Okay, great. And one other question on the RealPage type collusion issues. Does the Cartwright Act, will it address that issue as it stands today? Or does it need some sort of amendment to refer to this starting point idea?
Yeah, that's a great question. I think you get argument over whether or not, right? The Cartwright Act specifically means it has to say two companies have agreed to do something anti-competitive, right? The argument would be if I'm putting on my defense hat, well, just because I use this software doesn't mean I agreed with the other landlord to price fix. I just agreed to use this software, right? Well, I, as the plaintiff, would argue, well, you knew what the software was doing, and so by signing up, you knew that you were going to be that software was just going to be sharing information that's confidentially. It's as if you went to him and said, "Here's my pricing. Let's figure out pricing together." That's going to cause argument, right? That in and of itself, 6-7 months of briefing just to resolve that question, right? And so, in my mind, if I'm coming at this as a plaintiff, absolutely the Cartwright Act reaches that. If I'm a defense attorney, I'm absolutely saying it does not.
Got it. Okay, thank you.
No problem.
Thank you. It looks like the commissioners have no further questions, so we really appreciate your presentation and the report and the work of all the experts. So the next thing we have in our order of business is like past meetings, we have panelists who are going to do presentations that are 10 minutes each. And for this segment, we're hoping to be able to get these folks in before lunch. Professor Rubenfield, who will be speaking about abusive dominance, Jean Burris from the Coalition for App Fairness, Adam Cohen has comments on AI, Tejas Narachania, I hope I said your name right, has comments on AI, and Professor Feldman has comments on AI as well. So I'm going to turn it over to our technical wizards to start getting our panel up and running. All of these folks are appearing via Zoom.
And they know there's now 10 minutes.
Yes. Yeah, and just as a reminder, everybody has 10 minutes total. Thank you.
Okay. Professor Rubenfield?
Yes, can everyone hear me?
Yes.
Yes.
Okay.
Are you ready to start your presentation?
I am.
Okay. Thank you.
Sure. Let me begin by telling everyone that I'm actually an economist by training, even though I've taught antitrust law for 25 years. That would be a long story, but I'm going to it now. I was asked primarily to comment on the abusive dominance standard. I will be doing this with primarily an economic perspective, but also law perspective, because I have taught law for so long. My background is relevant here. What's probably most important is that I, as chief economist in the Justice Department, I put together the structure of the economic case in US v. Microsoft. Before I delve into abusive dominance, I cannot resist starting with a couple opinions, and then mostly I'll go into description. First of all, I do believe that California needs reform in the Cartwright Act to account for single firm conduct. And secondly, I've read the single firm conduct report carefully, and I support their primary recommendations. With respect to abusive dominance, as I will describe in some detail now, I actually am pessimistic about the use of the concept of abusive dominance. I believe that the Cartwright Act could be reformed effectively without using the concept of abusive dominance. Having said all that, I just want to actually go into some detail describing what other agencies around the world have done with respect to abusive dominance, so the commissioners can draw their own conclusion. I'm going to start with the European Union, which I think has gone into perhaps the most detail that would be informative to the commission, and then I will move on to talk about the United Kingdom, and then back to the US to talk about New York and about the Clara Act. So if you could move to the next slide. So there's been a big change, or will be a big change, in the application of EU law. To start with, just a second here. let me describe briefly some relevant aspects of EU law as it affects abuse of dominance. So the key aspect in the EU law that's relevant is Article 102 of the European Union Treaty. And that article specifically talks about the concept of market dominance and its abuse. But it's important to understand that as it's currently applied in EU law, there's an economics-oriented approach, and it's an approach that focuses ex post on the likely or actual harmful effects of alleged single firm conduct. In order to apply the abuse of dominance standard, you have to begin with a market definition, which itself is a tricky issue, which I won't go into detailed here. And of course, you need to show dominance. The EU is not quite clear about this, but it's often presumed to require for a 40% market share or greater. The important thing to note here is that the 4% number doesn't guarantee that a firm is dominant. And in fact, because it requires a market definition, it leads to significant battles about what the relevant market ought to be. Once a firm, a plaintiff has put together, or the European Commission has put together a showing of 40% market share or greater, then the question becomes what constitutes abuse of that dominance. And the EU historically has allowed for a very broad variety of anti-competitive practices. And the problem, as I see it, is that it uses a very imprecise economics-based definition of what is abuse. It says that exclusionary abuse is abuse that adversely affects consumer welfare, but it's actually not very clear as to what the concept of consumer welfare means. And here I have a brief aside, because you have a separate group that has looked into consumer welfare. I would like to interpret consumer welfare to really mean what is economic welfare, that is effects that adversely affect the economics of relevant parties. And those parties could ultimately be consumers, but they could also be folks involved in the supply chain, or it could involve, and that could involve workers, it could involve other supply chain providers. I think it would be better if we had a clear definition of what economic welfare really means. If you could move to the next slide, please. So prior to where we are today, the European Commission, in applying the statute, has relied heavily on the 2008 guidelines that were put forward by the Commission. That guidelines, as I suggested, involves an economics effects-based approach towards Article 102. That approach has had mixed results in the courts. Economists like myself tend to like that approach, but it's complicated. The process in the EU is a very long one, which leaves often both parties pretty unhappy from my perspective. There's less of a focus direct because the Commission guidelines say that you can show a dominant firm abusing its dominance without actually showing exclusionary effects. And it spells out various categories of potentially anti-competitive practices. Would you move to the next slide, please? So just 1 second. So more recently, the Commission in Europe has proposed a new set of guidelines. They're scheduled to go into effect in some form in the next couple months, but they're not finalized yet. The new guidelines would continue to utilize an abuse of dominance approach, but it would move away from an economics-oriented effects-based approach towards one that's a little more statutory and perhaps a little more regulatory than the economics-based approach. It's important to notice that the Commission, in proposing new guidelines, design guidelines that would make it easily applicable to digital markets. There would no need to have separate digital legislation. Of course, they have legislation in Europe, such as the Digital Markets Act, but that only really applies to the most concentrated firms in high tech. Move to the next slide, please. So overall, the European Commission operates under the guise that it must show conduct that departs from competition on the merits, but there's actually no requirement of proof that the conduct resulted in direct consumer harm and no de minimis threshold on consumer impact. Next slide, please. So essentially, what's important in looking at the European Commission view is to just look at what is a long list of the kinds of practices that could lead to exclusionary effects. And I just listed five of them here on this slide. Exclusive supplier purchasing agreements, rate rebates, predatory pricing, so-called margin squeezes, and a variety of tying arrangements. But this is not the entire list. This is just a selection. And critics of the application of these guidelines, which would probably include myself, worry that the list is too extensive without allowing for a proper set of defenses. If you could move to the next slide, please. So under the Commission's proposed guidelines, there will be a set of restraints that are essentially naked. Once the restraints have shown, it would essentially lead to per se liability. If there are practices that have no rationale except restricting competition, that would fit into the category. And I gave two examples here, but there would be many others. One is if you literally engage in a practice that would dismantle the infrastructure of a competitor, that would likely be per se liable. Or if you have payments that are directed specifically towards the goal of postponing or canceling the launching of competitive products, that would essentially be seen as a naked restraint as well. These are only two examples. I'm sure there are many others. Could you move to the next slide? So, well, before I get there, so I want to sum up again. We learn a lot from studying what's happening in the EU, and we'll learn a lot from the application of these guidelines. It's important to look at the EU, despite the fact that it's not a common law world, because they're so far ahead of us in some ways, in terms, for better or worse, in terms of their actions they've engaged in with respect to antitrust law. So I moved on to think about looking at that probably the most useful common law country that's looked at abuse of dominance, and that's the United Kingdom. The Competition and Markets Authority has been active for quite a few years. They've relied heavily on the Competition Act of 1998, which specifies an abuse of dominance position, and that uses that as more or less as the EU has done so, as the basis of looking to specific acts that might be in a competitive. That Competition Act has been modified and with further authorization to 2013, as I spelled out, but it has the same goal as the European Union. The UK authority is quite broad. It covers competition, innovation, and consumer welfare. Once again, from my point of view, it lacks a bit of clarity as to exactly what it means to be abusive. Next slide, please.
Professor Rubenfield, if you could wrap it up, you're just a little bit over your time limit, and we do appreciate your comments.
I'll finish in 30 seconds to a minute. So the next slide shows some of the abuse of dominance cases in the EU. You could move to the next slide. I did look at the New York 20th Century Bill, uses dominance in similar ways to what Europe would do. I've just spelled it out here. The commissioners can review this as they like. And then my final slide, I looked at the Competition and Antitrust Law Enforcement Reform Act. And there, again, there's a proposal to rely on abuse of dominance. It doesn't use the phrase abuse of dominance, but the concept is more or less the same. So I can stop right there. Again, wary of using the concept of abuse of dominance, but it should be aggressive in terms of putting into place a modification that counts for single firm conduct. Thank you.
Thank you. Next up, we have Jean Burris.
Okay, Jean, let's see. Yeah, you just, okay, right.
Okay, I think I've managed to join. Can you hear me okay?
Yes, thank you.
Excellent. All right. And I had some slides, if those are going to come up. Or I can just speak if we can't get the slides up.
We're getting those ready right now.
Okay. Oh, there we go. Excellent. Thank you, everyone. I'll be speaking from the perspective, I think, of a lot of the independent and challenger businesses in the tech world on some of these. If you could move to the next slide, I can introduce who we are. First, I just want to thank you for the opportunity to testify today. My name is Jean Burris. I'm Global Policy Counsel for the Coalition for App Fairness. We are a coalition that is an independent nonprofit organization formed to protect consumer choice, foster competition, and create a level playing field for mobile app developers globally. We originally formed in 2020, and we've rapidly grown from 13 founding members to more than 80 members worldwide, which collectively represent thousands of mobile app developers worldwide. What we've been doing for the last 4 years is advocating for legislation and enforcement to create a fair and level playing field for competition on and with the mobile ecosystems. So the ecosystems that everyone carries around in their pocket with their smartphones, and to constrain the power of those mobile gatekeepers. We could move to the next slide. So we're here to address two of the questions before you today. I think one is whether California law should be amended to include unilateral conduct, and two, whether some tech-specific provisions or legislation ought to be considered. Our shorter answer to both of those is a resounding yes. It's what we've been advocating for both in Washington, but in other capitals around the world. If you could move to the next slide. With respect to state level unilateral conduct, I think a little bit of history might be important to the considerations in California. So decades ago, it was Silicon Valley actually that was championing monopolization enforcement, then against Microsoft, who was the company at the time that effectively controlled access to the internet. And thanks to that effective enforcement 25 years ago, a lot of the tech giants that we now know today as household names were actually able to flourish and reliably invest and build businesses serving users of PCs. It's not at all clear that that would have been possible or as easy absent that monopolization enforcement against Microsoft 25 years ago. And it helped unleash innovation across Silicon Valley. I think we stand at a similar crossroads today as a few mega corporations now hold a similar position of control and access, and unleashing the next wave of independent innovation, investment, and businesses, and truly letting them flourish and be free based on their merits rather than their alignment with some particular business interests. I think success on that will depend on taking a similar approach to today's dominant platforms. With California specifically, if we, the innovation is far too important to this state and to the economy to rely solely on federal monopolization statutes and what, quite frankly, have become increasingly dismissive federal courts when it comes to application of federal antitrust law to unilateral conduct. It's not clear at all today, for example, that the Microsoft case would be decided in the same way, given the intervening 25 years of precedents by federal courts that have been hostile to these kinds of unilateral conduct claims, even against the largest and most powerful companies. I think that's why it's critical for California to amend its own statute and maintain policy independence from federal law. Amending California law to address anti-competitive and abusive unilateral conduct is crucial to ensuring that California remains a leader in technology, business, and innovation, rather than simply risk becoming a vassal to some of the world's largest and most powerful companies. Amendments should make clear both independence from federal policy and strongly consider adoption of standards like the abuse of dominance standard that's common throughout the world to address unfair and anti-competitive methods of competition by the largest and most powerful firms. You could move to the next slide. We also believe there's a unique need for tech-specific provisions. The issues, powers, and abuses emanating from these multi-sided digital platforms who are protected by network effects are well studied and understood. The biggest platforms control more than just price and output in any particular market, and the pattern is easily recognizable. Start with an open market to attract users and developers, accrue sufficient market power to dominate, and then begin to close down and reap benefits and rents that come from that power. Unfortunately, the lack of and delay in enforcement under existing antitrust laws has led to companies that are, quite frankly, more powerful and better resourced than governments today. We've proven approaches and successes in intervention. Giants of Silicon Valley today are household names that owe in some part because of interventions with Microsoft 30 years ago. However, what has happened is traditional Section 2 enforcement has proven to take too long to address abuses in time and has been too uncertain to effectively constrain the behavior of dominant firms. So for instance, the landmark Microsoft case took a decade, which was far too late for companies like Sun, Netscape, and Real Networks who got that case started to survive. And meanwhile, for another example is the Google search cases have been ongoing for more than a decade and still remain unresolved. And it's this uncertainty in Section 2 enforcement that allows dominant and powerful companies to feel no serious constraints on their conduct. You can move to the next slide. Most importantly, tech-specific provisions in California's antitrust statute would benefit the state's businesses and consumers. It would level the playing field with clear rules that would invite innovation and investment. Dominant firms are still free to innovate, invest, and compete, but they just simply can't use their dominance to compete unfairly or squash or hamper rivals. As a result, consumers, we think, will get lower prices, more access to innovative products, and new businesses from which to choose. And creating a quicker, more efficient path to rein in that market power is essential, as it will free enforcers from kind of the endless loop of litigation that simply comes too late often. If you could move to the next slide. We think there's many templates possible for tech-specific legislation in the US at the federal level. The Open App Markets Act and the American Innovation and Choice Online Act both garnered widespread support in the Senate Judiciary Committee from both parties. The European Digital Markets Act is now in force, and we're beginning to see the benefits of that legislation. And in the UK, the recently passed Digital Markets Competition and Consumers Bill could also provide a template. We will begin to see enforcement of that act beginning in 2025. If you could move to the next slide.
Mr. Burris,
Yes.
May I ask you a question? Sorry to interrupt.
Yes.
Could you go back to your prior slide?
Yes, for sure.
On the US federal box, could you explain the basis of the wide bipartisan support in the committee? What
Yes, so
generated that? It does not seem that this issue would generate wide bipartisan support naturally.
It might not seem that way, but it was surprising. So for example, there were markup hearings on both of those bills held in the Senate Judiciary Committee. And a perfect example is the Open App Markets Act, which is really a specific piece of legislation aimed at the mobile app ecosystems. That bill at the markup hearing got a 20-2 favorable vote to come out of committee. It never received a floor vote in the Senate, but in Senate Judiciary, which had an 11-11 split between members, it got a 20-2 favorable vote to come out of committee. And the American Choice in Online and Innovation Act, similar. It wasn't 20-2. I think it was more like 18-4, but it similarly drew pretty broad bipartisan support. So. We can go ahead and move to the last slide. Yeah, so our coalition represents a wide variety of independent app developers whose businesses are currently being limited or thwarted by today's dominant digital platforms. We think it's imperative that all California businesses can compete, thrive, and succeed and fail on the merits of their offerings rather than their alignment with financial interests of a handful of mega corporations that act as gatekeepers. We think this will ensure that California consumers can benefit from lower prices and innovation. And improving California's antitrust law ensures that what I think have been kind of ideological developments in federal courts around Section 2 enforcement over the last 25 to 30 years, that those federal policies aren't necessarily imported to California by default and don't limit the next wave of innovation and successes in Silicon Valley. Enacting the tech-specific gatekeeper restrictions will ensure that I think California remains a leader in innovation and business development. And quite frankly, I think both the United States is a little behind on this at this point, where we've seen tech-specific legislation in Europe, in the UK. There are efforts in Japan, in Korea, in India, in other jurisdictions around the world that are starting to get out ahead of this. I think to create, to some degree, the same world that got created in the early 2000s that allowed really the last 2.5 decades of explosive business growth in Silicon Valley to take off, because businesses could reliably invest in building their business on PC computers. We're in the same world roughly today, where mobile devices have become the gateway to the internet and the way to do business on the internet. And there are two companies kind of in the same position of control that Microsoft was in 25 years ago, and to kind of unleash that next wave, we think tech-specific legislation is necessary in order for it to happen in a time frame that matters today and matters to companies that exist today. So with that, I thank you for the opportunity to testify, and happy to answer any questions.
Thank you.
So next up, we have Adam Cohen. If you could tee Adam Cohen up, please.
Adam, are
Hello.
you ready to start?
Yes, can you hear me?
Yes, thank you.
Perfect. And if you could bring up my slides, please. Thank you. Well, first of all, thank you for inviting me to be here. I appreciate the diverse perspectives that this committee is inviting to speak on these issues, and I'm very happy to contribute on behalf of OpenAI. I lead our economic policy work and want to give you a brief overview of the developments in the artificial intelligence field that have been getting quite a lot of attention over the past 2 years in particular. OpenAI is developing what are known as large language models, or sometimes called foundation models, which are a type of artificial intelligence program that can recognize and generate large amounts of text, and in some iterations can also generate images, video, and speech. If we go to the next slide, please. I don't know if, can folks see the next slide?
Yes, a little bit of technical difficulty. We're working on it one moment.
I can walk you through it while we tee that up. Just to explain that OpenAI, OpenAI was founded as a research lab back in 2015, but folks probably hadn't heard of us then, and probably not until November of 2022, when we launched an application called ChatGPT, which is known as, sometimes called as a chatbot, based on a large language model that we had developed. These chatbots you engage with conversationally. They can help you get answers to questions. They can suggest ideas. They can solve increasingly complex problems and do a lot more. ChatGPT, I should note, has been the fastest growing tech product in history. We went from not being known at all to having 1 million users in 5 days and 100 million users within 2 months. And we can go to slide 3. We are incredibly excited and optimistic about the future of this technology and the power of AI to help tackle really hard problems across medicine, scientific research, creative fields, and other areas. This type of artificial intelligence, unlike algorithms, which I think should be considered differently and are actually a different type of technology, but this type of artificial intelligence is a highly flexible, general purpose technology. Our models, as I described, they're known in the industry as foundation models, since they're trained on broad and diverse data sets and have a wide range of applications. These are the basis for the applications that we provide to consumers and to businesses. Some of these applications are enabled by our underlying tools, are being developed by other developers as well. So they're available to third-party applications, I should say. Those third-party developers might be developing them for particular use cases. They can be applied to a range of different problems and a range of different business and consumer needs. If you go to the next slide, please. Great, thanks. This shows you a little bit about how foundation models can be used to create applications with specific or general use cases. The ones on the left side of the screen, or at least my left, are applications created and provided by OpenAI. On the right, you can see how customers can use our application programming interface, or API, to create their own models, to create their own applications, and basically build their own tools off of our underlying technology. We go to the next slide, please. And this just shows you that these models are developing very rapidly and improving very rapidly. You should know that they are incredibly expensive to produce. For the past few years, we and other LLM developers have been operating with the idea that more data and more computing power, the more you put into LLM training, the more that you would get out, the more capable the finished model would be. And we've seen that that's mostly true, but also some signs of diminishing returns to that approach. On the right side of the screen, you can see one of our latest models called O1 Preview, which takes a slightly different approach, using a method where the model actually spends more time thinking, or we would describe it as reasoning through problems. And we have seen from that approach that we can get even better results from the same amount of computing power. And when applying even more computing power to that, can get exceptionally better results. This model has tested, taking standardized tests like the LSAT and others. It tests better in many cases than PhD level students across a range of fields, particularly scientific ones like physics, math, chemistry, and computer science coding. We think that this approach is going to lead to, which is new and we've pioneered, is going to lead to even better models in the near future. Next slide, please. I don't know if it's flipping for folks, but there we go. We do think it's crucial that these models be developed with safety in mind, and be tested rigorously to ensure that they are safe for use. This has been a priority for us since our founding back in 2015, and we devote a huge amount of resources to testing our systems through these various techniques to ensure they don't respond to harmful or inappropriate content. There's been discussion earlier about algorithmic collusion. When I ask ChatGPT about issues that might point in that direction, it consistently comes up with a response telling me that it will not assist me with illegal behavior or any unethical behavior. And this safeguard is really the result of extensive engineering efforts and investments around safety. Next slide, please. You can see here that I did describe that training these and building these LLMs is incredibly expensive. This is a look at the key inputs. What do you need in order to build an LLM? There are public estimates that Google's recent model, known as Gemini Ultra, cost over $190 million to develop. You can see that LLM models need training data, available training data. They need compute and the energy that goes with that. They need chips. These are pretty well known now as crucial inputs, and in some cases there are more constraints than others. But as I described, this is a technology that emerged 2 years ago and has been a source of massive inward investment, and complementary technologies like these and capabilities like these are also subject to enormous investment at the moment. Next slide, please. I don't want to give the impression that we're the only firm operating in this space, nor that this slide is comprehensive, but this just gives you a little view of the different, I'd say, layers of the industry at the moment. These have taken shape over the past couple of years. I'm not sure that they will persist in exactly this fashion over the next 2 to however many years. There are lots of different folks playing at these different levels. There are, a handful of cloud providers. There are a handful of leading chip manufacturers, but lots and lots of investment going into those critical aspects for developing these AI tools. We can go to the next slide, please. And just zooming out a little bit to look at the uptake of this technology and think about some of the potential impacts. At this stage, again, we're almost at our 2-year anniversary of having launched ChatGPT. We see that roughly 40% of Americans have used ours or similar tools, slightly more at home than at work, which is kind of interesting. And we expect this to continue to grow. And then the next slide, which is my last, please. This is from a study published by the St. Louis Federal Reserve Bank recently, which shows you the rate of adoption, that 40% rate in the context of other general purpose technologies. You can see here that this was faster than the personal computer and faster than the adoption of the internet. So thank you very much, and I'm happy to take any questions.
There's one question.
Yeah, thank you for your comments. I think one of the major takeaways from your presentation is the current significance of AI and its obvious potential for exponential growth in the marketplace. What I didn't hear was, and I'm curious if you would state an opinion on this, whether you have a view on whether those facts that you presented to us about the current market position of AI and its likely future course, how you think that should weigh on our considerations about our antitrust study in general, and specifically whether there should be particular consideration in the recommendations for digital projects in particular, and even more specifically for the AI products that you've been discussing.
Well, I in my previous role, I worked at Google for 14 years, and in 2022, there was a lot of discussion about whether or not there was a need for specific digital competition or antitrust rules to govern relationships between different firms and different layers of, various technology stacks. Despite, concerns about large players versus small players, OpenAI, as an independent company, was able to build an innovative new approach and grow faster than any other technology service previously. And I think it's notable that we are a California-based company. Our headquarters are in San Francisco, and we were able to find a way to change the technology and change the approach in a way that others, much larger, better endowed firms than ourselves, have had to follow. I think that's worth keeping in mind. That innovation, that spark, is still very much present in California.
I have a question, Mr. Chair. It seems, based upon the information you've provided, that there are many barriers to entry. You were talking about, startup money of $1 billion plus or so. So looking forward into the future, it seems like that is a huge barrier for competition. And I'm wondering if there have been any discussions at the federal or state level for government grants or funding to spur competition, particularly for AI or other similar platforms or technology.
It's an excellent question. And I think what's remarkable is that our leadership in this field actually has promoted and prompted a huge amount of additional investment in other players. Engineers have hived off from some of the leading developers and are starting their own firms, and without any technology to show for it, are able to attract multiple billions in funding, knowing that the development and scaling of these products is quite expensive. But the venture capital money, particularly in the United States, is there and is rising to meet that challenge. I'm based in London, despite being a native Californian. There is much more discussion in Europe at the moment about whether the state needs to step in to provide that funding capacity, which is in abundance, frankly, in the private sector in the United States.
Okay.
Okay, thank you very much. The next up, we have Tejas Narachania. I hope I got your pronunciation at least close. And do we have this person ready to go? Thank you.
Good afternoon, everyone. I'm delighted to have the opportunity to speak with you, and thank you so much for hearing me out. I'm here to talk about competition and AI, and in particular—
Professor, we're having a little bit of difficulty hearing you. Could you keep right at the mic?
Let me try to do that. Is that any better?
We'll see. Proceed. We'll let you know if we have trouble.
I'll do my best. If I have to, I will turn off the video and just stand right next to it, next to the mic. So I'm just wanted to offer my thanks for the opportunity to speak with you about competition and AI. And on the first slide, the next slide, I'll give you a little bit of background about who I am and where my remarks are coming from. So I am as the next slide suggests, I'm a law professor at the University of California, Berkeley, where I focus on a range of policy and regulatory matters related to technology, including telecommunications, platforms, and of course, AI. My remarks build on a body of work, some of which is solo authored, some of which is co-authored, some of which is still in progress and quite tentative. But I should just emphasize that anything that I say are my own comments. They don't belong to my co-authors, and I certainly don't speak for UC Berkeley or the law school. So as the previous presentation suggested, there is a stack to AI technology. And so this is on the next slide. That stack begins with applications, then below applications are models, below models are the computational infrastructure, and below that is the chip. And the market for AI applications seems to be thriving. You know, it's not every day you seem to hear of a new AI application or a new chatbot. And so one of the reactions that I get when I talk about competition in AI is, what are you talking about? It seems like competition in this space is thriving. And I think what I want to direct your attention to is the layers below the application, or the layers below the application layer. Because in those layers, you see an increasingly concentrated set of inputs to AI. And to make this a little bit concrete, on the next slide, I just substitute the layers with names. So you have Bing Chat. Bing Chat is an application that we might use. Bing Chat sits on top of GPT. GPT uses the Microsoft's Azure compute infrastructure. That compute infrastructure employs NVIDIA chips. Right? Likewise, on the next slide, Alexa AI uses Anthropic's model. That model uses AWS's compute infrastructure, and AWS's compute infrastructure, once again, uses NVIDIA chips. And so the thing that I want to point your attention to on the next slide is that it's concentration in those lower layers in the stack. Concentration among models, among providers of cloud computing infrastructure, among the designers and manufacturers of chips, that is especially concerning. That is, the application market may appear to be thriving, but that application market depends on these lower markets, and concentration in those lower markets is either quite high or is likely to become even more intense over time. So I want to talk through each one of those layers, starting at the bottom and working my way up. So in the next slide, I start with chips or microprocessing hardware. And I don't think I'm telling anybody anything new here. If you're paying attention to this space, you'll see that federal regulators have already recognized the dangers of concentration in this context. The Department of Justice has kicked off antitrust probes into NVIDIA because of allegations of unfair conduct in regard to its GPUs, or one of the core computational inputs to AI. So the next slide says that the design, production, and sale of microprocessing hardware is highly concentrated. I can give you some estimate numbers on that. NVIDIA has about 85 to 90% of the market of GPUs. GPUs, of course, aren't everything. There's other microprocessing hardware that goes into using or developing AI or AI applications, ASICs, for example. But concentration in the GPU market gives rise to substantial concerns about pricing, concerns about tie-in conduct, concerns about vertical leveraging. And these are all concerns that have been reported in the context of reporting on the US Department of Justice's investigation. In terms of manufacturing, on the next slide, I just want to say one brief word, which is that manufacturing is also highly concentrated. TSMC, or the Taiwan Semiconductor Manufacturing Company, again, has a stronghold on manufacturing of chips. TSMC counts as among its customers AMD, Qualcomm, Apple, and of course, NVIDIA also. There have been some industrial policy moves in the United States to try to address some of this concentration. The CHIPS and Science Act from a few years ago tries to subsidize new competition, new manufacturing capacity in the United States. But that's going to take some time to come online, and it's not clear yet how effective that will be, though I'm hopeful. I want to move on next to the cloud infrastructure, or the computational infrastructure. And here I'll just say that cloud is complicated. That sort of sussing out exactly what to do from a policy basis is complicated because the services offered by these cloud providers is complex. It includes not only raw processing power, right? The computers and servers themselves, but also a range of auxiliary software services that sit on top of that hardware. Operating systems, databases, other sorts of business logic. Notwithstanding that, it's important to recognize that the market for cloud services is quite concentrated. AWS has about 1/3 of the market. Azure has about 1/4. Google Cloud has about 10%. And then there's a tail of other providers, but none of them seems to constitute more than 5% of the cloud market. This concentration seems to be primarily a consequence of switching costs. And to the extent that regulators internationally have looked at the cloud market, here I'm thinking of the United Kingdom's CMA, they focused primarily on egress fees. But I'm not sure that egress fees are the primary driver of concentration in cloud computing. And so on the next slide, I think what the high level point of this slide is that the key driver to switching is not egress fees, but rather portability, engineering, technical portability. Enterprise cloud workloads depend on.
Professor, can we interrupt you for a second?
Yes. So for the egress fees, which are the charges that the cloud providers impose when the data is moved, right, from the cloud storage to the internet, why has it been the focus?
So that is a great question. Why have regulators focused on egress fees? So I think one, they are an easy target. I think they probably are somewhat anti-competitive, but I don't think they are the key driver of concentration. That is, I'll clarify my comments to say I think we should still do something about, egress fees, unfair volume discounts that have the effect of locking users into a particular cloud provider, untoward software licensing practices. Those are some of the things that the CMA identified as barriers to switching. And I think that those we should still address. However, I think that even if we address them, they are unlikely to be sufficient to overcome the technical engineering impediments to switching that are really driving the sort of concentration.
Thank you.
Yeah, my pleasure. So it's these few large clouds that have the suite of services that many enterprise customers want. So they come to them first and then they get stuck because it is very difficult and costly to switch from Google to AWS or from AWS to Azure or from any one of them to a small provider. However, and this is the thing that I want to say next. So on the next slide, emerging workloads such as AI model training are more portable. Cloud up until now has been focused on a range of enterprise software services that rely on this set of services that AWS and Azure and Google have built. That is less true for AI. That is, AI is much more computationally intensive. It much more just needs the hardware and doesn't need all these extra services. And so because AI model training, AI computational workloads seem more inherently portable, I think now is a really good moment to try to preserve that portability and try to grow competition in cloud. How do you facilitate and maintain greater portability in this subsector for AI model training and more compute-intensive workloads that are less dependent on this additional suite of software? By nurturing some of these other cloud providers. I call them smaller cloud providers. I mean smaller in terms of share. They're still pretty big companies like Oracle and IBM. One more caveat to this on the next, actually, let me give you some ideas first, and then I'll give you the caveat. So the ideas here include things like facilitating cross-cloud services or facilitating the development of companies that make it easy for you to port from one cloud to another by acting as a sort of broker or layer on top of a number of cloud services. Think Kayak or Orbitz for airlines, a single entity that you go to that can then direct you to different cloud providers. Technical standards for interoperability to make it easier once you develop something for cloud A to switch to cloud B, and of course, enforcement and post-hoc review. I also think that it's really important to continue to track vertical integration, particularly with chips, because if chips are not available to would-be cloud competitors, they won't be able to offer competing services. So it's important that a range of cloud providers have access to GPUs in order to offer AI model training or computational services.
Professor,
Yes.
we have another speaker to get to, so we're hoping you can wrap it up.
Yes, I will
Thank
move
you.
quickly. Sorry about that. Okay, let me get to models and then I will run through models quickly and I'll be. So the thing I'll say about model development is that it is structurally inclined towards concentration. I wrote this in a law review article a couple years ago, but it's not just me saying that. In a recent RAND research report, a set of economists said something similar. And so as you'll see in the next slide, they sort of go through a number of criteria that that are either suggestive of competition or concentration, product homogeneity, economies of scale and scope, network effects and sunk costs. And the previous presentation, I think, talked quite a bit about how there are high sunk costs or barriers to entry, high fixed costs, network effects, economies of scale and scope. And all of these, as the next slide suggests, you sort of have check, check, check. Model development meets all of these criteria. You're likely to see a natural monopoly or tendencies towards concentration in model contexts. That tendency towards concentration gives rise to a number of problems, as I note in the next slide, things like pricing, quality concerns, concerns about vertical leveraging, and abuse of network effects. The next couple of slides walk through some other scenarios. What about open source, or what is the future of the model space look like? In the interest of time, I'll skip over those, but I'm happy to answer any questions you may have about them. And then I'll just return to applications. There are a lot of applications, and that's where I started. However, we should still watch for self-preferencing like behavior. We should be concerned if a certain model developer prefers their own applications and makes it more difficult for someone to develop a competing application. I'll just note here that I'm concerned about competition within AI, and I'm not here talking about the other sorts of competition, things like algorithmic collusion that were the subject of the very first presentation earlier. And beyond competition, on the last slide, the thing that I'll say is that we should also think about the effects, not just for competition, price and quality, but also security and resilience, equality and democracy. Concentration in this stack has implications for the reliability of our infrastructure, equity in our society, and the future of democracy. I could say more, but I will stop there. Thank you so much for the time and opportunity.
Thank you. And we have one last speaker before we break for lunch, and that is Professor Feldman.
Hi, are you folks able to hear me?
Yes, thank you.
Yes.
Thank you very much. Well, as the person who's standing between everyone and lunch, I will start my little timer here when I start to make sure I stay within my 10 minutes. I'm Professor Robin Feldman at the University of California Law in San Francisco. I direct the Center for Innovation and its AI Law and Innovation Institute. I want to start with a couple of overview thoughts and things I think that will fill in some gaps that may be helpful along the way. I'm going to speak about not tech in general, but AI specifically. I want to start just as a reminder with the old saw in antitrust law that big isn't bad. It's what you do with your size, but just being big in itself isn't necessarily a problem. The second overview thought is to keep in mind the structure of the industry, the importance of the structure of the industry. I know several speakers have talked about industry structure. When you have a structured industry that lends itself to an anti-competitive structure, that's more of a problem. when you have a quickly evolving and emerging industry, such as AI, the challenges are very different. So I have for myself something I call the Robbins Rules of Order for AI. And so I'll start with the first one, which is that myth-busting matters. I want to talk again for just a short moment about what is AI. It's not a person, it's not a thing, it's not an it. AI is a process, a way of doing things. It's a way of analyzing information and making predictions, even if the set of information you're using is vast and the number of layers of analyses that your query goes through are so large they're difficult to comprehend or to follow. If I were to do a very, very loose analogy, I would say that for jurisdictions that have tried to do general AI regulation, the problem is it's a little like trying to regulate using linear algebra. It's very difficult to make that work well. Slide, please. Thank you. So LLMs are the latest rage because of the explosion in large language models. Those are generative models. And I just wanted to show you the circles here and just point out that the focus is on a small, when we talk about all of the LLMs, we are tending to focus these days on a very small piece of artificial intelligence. Even the next level machine learning didn't appear in 2022 with the marvelous appearance of ChatGPT in public, but it's been unfolding, albeit more slowly, for many decades. So I don't have a lot of fancy slides on the artificial intelligence section. I will be back when we talk about the healthcare section, and I promise you I'll have more slides there. I'm just going to keep watching my sign here. So think about competition problems in AI on two levels. First, the industry that creates AI products for the public or for other producers. And there you can think about the inputs and the outputs. And then I also, on a second level, think of the effects on other industries that may happen when those industries deploy AI tools or techniques. And in both cases, the question is, what's the structure of the industry? With the AI industry, we've heard in different pieces this morning, there are choke points, chips, computing power, data, labor. Those are the choke points people talk about. I know a couple of folks talked about whether dollars are a choke point because of the expense of making foundational models or the larger models on which things rest. And to say that the general economic perspective on this is that capital in our society is not usually considered a choke point, as you'll see by the panelists who answered, that the venture capital community is quite willing, in some cases maybe over willing, to provide capital for all types of AI enterprises. So I'm a techno-optimist, but I'm also a techno-realist. And with both of those in mind, I'm always reluctant to suggest stepping in for the government unless I'm certain that the cure is better than the disease we're worrying about. And I think if you look at the choke points, it will show you that there's some limitations in thinking about that. So one of the choke points I mentioned is skilled labor. The engineers who have the capacity, the training, experience, and knowledge to work with these very complex algorithms and types of programs are scarce. So we know skilled labor is a problem, but I would be loath to see California step in and try to restrict labor in any way. There's a famous study that compares the Silicon Valley area and its development with an area outside the Boston universities. It's called Route 129, where they also had a lot of startups. Comparing the two, Silicon Valley exploded while that area did not. And the research points to California's rules in which we don't enforce non-compete clauses. So workers are free to go to new places, and how that has brought an explosion in innovation in our areas. With computing power, I think that's a really interesting area to look at. We have a smaller number of those who control the compute power. Generally, we're talking about 3 firms, but competition is fierce among them right now. And it is likely, if you think about what AI is doing right now, that you will have larger players who accumulate the compute power or accumulate the data to do that. The field is likely to go in that direction. And I think of it as the sport of kings. Finally, that's today. Even there, things are changing. There are firms that are working with architectures that don't require so much compute power. They're more efficient at learning from what they do. So we may not be there tomorrow. Finally, and this is one of the most important things I want to point out in the last few minutes I have, when we talk about contemplating potential competition action, I always want to ask who benefits. It ought to be consumers and innovation, in my view. But I think there's another perspective. So people talk about a great threat from rogue robots taking over the world. My own view is that the greatest AI threats are going to be human generated. And I'm going to say this very directly. I find that's the best way to say it, although it may be controversial, but I don't believe we're in just an international race for AI tech the way we had races for internet or smartphone development. I believe we're in a new type of Cold War where AI will be essential both for military and non-military defense and purposes. Easy to look at the military, precision targeting, predictions, drones, targeting and protecting infrastructure like water and power and communications and transportation. Anyone who was crowd-struck last summer understands what it means to have disruptions in some of these. But there is a deeper level on which I think the developments of AI and being at the forefront are important to protect values that we hold dear as a nation and that distinguish us from other systems such as dictatorships. So we hear people talk a lot these days, mainstream press, about the way TikTok as an app draws our young people in, measures what they respond to, sends them other things to see what they respond to, how long they look at each piece, what part they look at, what they go back to, and then uses that to enhance and expand their own reactions. So we talk about that in terms of worrying about folks who are, their own depression then becomes enhanced, their own feelings of lack of self-worth become enhanced. And while all of those are essential, I think we'd be foolish to think that these types of apps can be deployed only to amplify what we are feeling. They can, and possibly are, already being deployed to shift our viewpoint of what we ought to be feeling. There's some data that wonderful research that shows that if you want to nudge people's behavior, one of the best ways is to say that your neighbors are doing it. So we could easily be watching lots of bots telling us that our neighbors are doing these things. The final point I want to make as my clock ticks down is that all laws are not one size fits all. Europe has the most extensive AI legislation, but Europe is a set of consumer nations. We're a producer nation, so our interests are not necessarily going to be the same. My final thought in this is that if you are in a Cold War, and the best tools that we can think of are things that might hamper the innovation in the industry that we want to help us win this Cold War, or to break up in some ways the large concentrations of data or compute power or other types of things that may advance where we are, I think we should think carefully before doing that. Thank you very much.
Thank you for your presentation, and we'll see you after lunch.
Commissioners, what length lunch is your preference? 30?
Perfect.
Well, let's be back at quarter of, because it'll take a minute to go each way. So 1:45 in recess.
Okay, it looks like Robin may have already been up there. So Professor Feldman is our first up in our afternoon session. We have Professor Feldman, Professor Goodixon, Michelle Rivas, and Dan Robbins and Aaron Megardician, who will all be speaking today. I'm just going to remind everybody who's appearing via Zoom to please speak up so we can hear you. We had a little trouble last time, and for each segment here, you have a total of 10 minutes. So with that, I think we can turn it over to Professor Feldman.
Thank you. And would you kind of go to slide 5, please? I think you're probably on slide 1, 2. I think went back to the beginning. Oh, there we are. Thank you. Appreciate it. All right. Hope everyone had a nice lunch, and it's nice to be back here before you. I will hit my timer. So I want to talk about an aspect of the pharmaceutical industry, both in terms of its relation to AI and also on its own. Slide, please. I'm going to start by talking about the hub and spoke conspiracy that someone else mentioned earlier. It is considered an anti-competitive behavior. But normally, we don't allow horizontal competitors to speak to each other and to coordinate together. We want them to go head-to-head in competition. A hub and spoke conspiracy can allow them to do that. So the center is the hub, that is the one who acts as the facilitator. And then going out from each are the competitors. Those are the spokes, and the entire this allows the competitors never to speak to each other, never to coordinate with each other, because the hub in the middle is coordinating them. So that's a general hub and spoke conspiracy. So now I want to talk a little bit about what are PBMs. Slide, please, because they are an essential part of the drug supply chain. So PBM stands for Pharmacy Benefit Managers. They sit at the center of the pharmaceutical industry. We should already have an image of the hub. They represent the health plans. They negotiate against the pharmaceutical companies for prices, and then they help the health plans design the formularies. That is, whether patients can access a particular drug and how much they will have to pay to access a particular drug. Slide, please. So PBM is a highly concentrated market. It is already vulnerable to potential hub and spoke type of arrangement, in which you can think about the spokes as the different players in the like large pharmaceutical companies. There are other ways you could think about those spokes. And the center again is the PBM, moving among all of them. There are 3 PBMs who cover 80% of all prescription drug sales in the United States. Those players have access to massive amounts of sensitive and non-public data about what people are buying and all of their characteristics and when and how. That can be used to identify trends and patterns in the industry, and the power to do that is being ignited by the advanced algorithm ability to analyze increasingly large data sets and draw increasingly accurate collusion. So you spoke at the beginning, the commissioner spoke about the question of whether California has needs for its own laws, And I think here you will see some opportunities for California to have its own laws, both for concentration and for algorithmic collusion. So next slide, please. This is the final on the PBM industry context. It has unique informational asymmetry. It is a heavily regulated industry, which can make it more difficult for competitors to enter, and also provides opportunities for entrenched players to use that system to help block out new competitors. And the price is generally inelastic, which means that when my health and my comfort are at risk, I will pay a lot for it, especially if my health insurer or the government is paying a chunk of that. So there's a lot of room for what I would call price irrationality, although economists might argue with me that it's perfectly rational. So within that, you have the setup for an industry that can be set up as something that is primed for a hub and spokes type arrangement. Slide, please. Okay, so again, the PBM's at the center. They are negotiating with all of the pharmaceutical companies. That could be the spoke, or they're negotiating with all of the large numbers of the health plans. Those could be spokes. Or you'll hear someone talk about the different pharmacies and vertical integration. You might be able to think of it that way. Slide, please. So that was just a way of talking about AI and its potential to have this hub and spokes relationship. What AI it allows it to do that a central player such as a PBM could not do is to figure out with much greater precision what is the optimal price for all of the competitors to enter into, and what are the optimal terms for them to do that in a way that will help both the PBM and that will help the horizontal competitors all around it. That's the problem we have with the PBMs. They may only extract between 10 and 20% of the cost of what finally you pay at the pharmaceutical counter, but they play an outsized role in all of this, pushing the pricing up. They are likely to play an increasingly outsized role because the power that AI gives them, and that is what some people call the potential for algorithmic solution. I want to turn now to some areas in the pharmaceutical industry that are of interest to antitrust and that don't relate to AI. So the first is concentration in the pharmaceutical industry. Slide, please. Thank you. So large pharmaceutical companies have undergone a wave of consolidation, 3 waves actually. The first merger wave was between 1989 and 1990-91. The second merger wave was between 1994 and the early 2000s. We are in a third merger wave that began in 2010 and is continuing. Next slide, please. So after the first and second merger waves, we saw the 60 large pharma companies merge into 10. We also saw a sharp drop-off in new molecular entities, new medical, the core of what medicines are. We saw a sharp drop-off in new drug applications and a sharp drop-off in R&D spending. During this period of time and a little beyond, 5 to 7% of the smaller acquisitions that happened were estimated to be killer acquisitions. That is, you acquire someone who might be a competitor and then you put it on the shelf so it's no longer a problem. As of 2017, only 4 companies produce more than half of all generic drugs together. And we found that merged companies spend less on research than their non-merged counterparts. Slide, please. So those were the effects of the first and second merger wave. The current merger wave, we see smaller pharma companies produce roughly 50% of new drugs. In other words, startups or spinoffs out of university. Large pharma then acquires the small firms to source innovation. Big pharma plays the role of gatekeeper to the FDA. And we are finding that initial indications that there is a leakage of the dollars coming down the line. In other words, if I'm a small biotech and I invent a massively effective new drug and you buy it from me, you should buy it from me for the present value of what I'll make in the long term. I should be able to get my portion of that. However, what we're seeing is that that's not happening. What's paid to the smaller companies, at least at first appearance, seems to be much smaller than the long-term value is worth. There's another important aspect to what's happening with the current merger wave. Innovation has shifted heavily towards treatments for rare diseases. So 34 out of 59 new drugs were so-called orphan drugs in 2018. And that was compared to 5 of 21 a decade earlier. And we're seeing staggering prices in these categories of drugs. So in short, in this last merger wave that we are in, we see more new drugs emerging, but they're helping fewer people. It's all at high prices. And a fair amount of this comes from government choices and incentives that were built in for very good reasons, but have distorted where the innovation trend is going. Next
Professor
slide.
Feldman?
Yes.
Can you please define what orphan drugs are?
Of course. So Congress initially passed a law that was intended to provide innovations for medications that would, and I'm quoting from the statute now, would not be reasonably, you would not have a reasonable possibility of getting back your investment if you tried to work in the space and you came up with a new drug, because there are so few people who might use the drug that you couldn't make very much on it. So that was the first definition of orphan drugs. A few years later, Congress came back and amended the statute, and instead of having that definition of where there's no reasonable likelihood that you will get back your investment, they changed it to certain caps. And one of them is serves a population of under 200,000 patients. And that caused an explosion in orphan drugs because with a lot of the newer drugs, particularly cancer drugs, one can separate, it's called salami slicing, separate the different patient populations. So you can say essentially the patient population that opens its car doors and is over 6 feet tall and hits its head on a morning is one group, and the under 6 feet tall that hit their head on a lamppost is another group, and you just slice your population smaller and smaller. Orphan drug gives you 7 more years of protection after your patent or other protections you get. It's an incredibly valuable type of incentive from the government, and it's been extraordinarily effective along with some other policies. The problem is now we are seeing companies shifting into these narrow areas because they can make so much profit on them. And they're not looking at large things like heart disease or reproduction or any of the many other things that are affecting large numbers of people. Is that helpful? Okay.
Very. Thank you very much.
All right. So I'll go back to the last minute here. Point is simply that our innovation system is askew right now under the current merger wave. Next slide, please. So I also want to talk again about what we might do throughout all of these. So on the federal level, the normal approach, if there's a concern about a merger, is to ask the company to divest drugs that are in the pipeline. idea is that those drugs will go out and then be competition for whatever's happening in the merged company. So I'm nearing the end of a study looking at whether pipeline divestitures work in terms of, do they actually provide competition in the market? I looked at dozens of pipeline drugs divested over a period of time, and at least 80% never entered the market at all. There's no competition. We're chasing down the last stragglers to see if there's, even if they enter the market, did they actually achieve any market penetration? Did they get anywhere? I suspect the answer for a lot of them will be no. Last slide, please. So the point is, this is just some selected publications, but the point is in answering the question whether California should consider its own law is that essentially, I think there's a lot of room for better antitrust tools and better use and understanding of antitrust tools that, particularly within this area, the federal government has not stepped up to do. Things like looking at multiple effects rather than just looking at one narrow activity at a time. There's a lot of room in there. The point of what I said about AI earlier in the day and what I'm talking about here is really the same. There continue to be spectacular innovations in both areas, but we have to keep our eye on the public benefit from the innovation. And we have to make sure that our antitrust tools, rules, and policies keep that competition robust and are likely to help, not harm. Thank you. May I ask the Commission's indulgence that the folks who scheduled me here were very kind, so that to put this at the beginning so that I could try to leave in time for a medical appointment. So could I possibly ask if there are questions on my presentations at this point?
Absolutely. Are there any questions from commissioners? Hearing none. Thank you.
Thank you. It was a pleasure to be here.
Thank you. Okay, so next up in our afternoon agenda, we have Professor Gudikson, who will be speaking to healthcare issues in the antitrust arena. And she should be up momentarily.
Hi, thank you for having me today. Are the slides?
Can you speak up just a little more or go closer to the microphone, please?
Yeah, can you hear me now?
Yes.
Yeah, thank you.
Thank you so much for having me here today. I run a research team at UC College of Law San Francisco called the Source on Healthcare Price and Competition. I want to preface my remarks by saying I'm not a lawyer, but I actually am a policy expert in this space. I've drafted legislation and worked with many states that are seeking to identify solutions to address healthcare consolidation and affordability, including working as a consultant for the Office of Healthcare Affordability here in California on their merger review part of that office. I've been asked to talk about the current state of consolidation in the healthcare industry, its impacts, and what states can do about it. So at the first, I like to point out that healthcare costs have just really skyrocketed. So over the past 24 years, during a period of relatively high inflation, healthcare has increased much more dramatically than pretty much anything else that the Bureau of Labor Statistics tracks. And you can see at the very top there are hospital services. Next slide, please. And if you look at the increase in costs, this data is just from the past year from KFF. The increase in prices for medical care is significantly above the consumer price index for services that are not medical care. But you can see that hospitals and nursing homes represent a huge portion of that increase, basically almost all of that increase, with hospitals being nearly 3 times the price increase of other medical care overall. Next slide, please. And there's a large body of economic and research evidence that finds that consolidation is the primary driver of high and rising prices for the privately insured, those with commercial insurance. For example, one paper found that hospitals that are monopolies that don't have competitors within 15 miles have prices that are 12% higher than competitive markets. Many studies have looked at mergers of two hospitals in the same market and found very large price increases, between 3 and 9% in just the first year following the merger, with some studies finding 20 or even 40% increases for specific hospital mergers. It's important to note that these kinds of mergers really change the market dynamics because the prices increase by that percentage at the hospital that was acquired, but they also increase in the acquiring hospital, so the whole system is able to rise their prices. And even at bystander hospitals in the same market, that can just shadow the price increases of that dominant system. And newer research is finding that prices increase 3 to 5%, even when the merging hospitals are in completely different markets or even in different states. And I'll just sort of summarize all that research to say that in 2020, the Medicare Payment Advisory Commission, or MedPAC, concluded that the preponderance of evidence suggests that hospital consolidation leads to higher prices. Next slide. And in addition to this horizontal consolidation, vertical consolidation is growing relatively rapidly and is also a concern. So as of 2024, more than half of US physicians are employed by a hospital or health system, and another 23% are employed by corporate owners like private equity groups. Again, there's a pretty large body of evidence about price increases post-merger with a health system, for the hospital, for physicians, for clinics, with no demonstrated quality improvements. Those are really what tends to be justifications for these mergers. And hospital ownership of physician can also alter referral patterns. So there are a number of studies that show that once physicians are acquired by a health system, there's increased inappropriate imaging, so increased MRI or lab tests that really are of no benefit to the patient. The data on the right, that's the wrong source, I apologize, is from a California Healthcare Foundation report. This is just showing California and the percentages of specialists, that's the lighter green, and primary care physicians that are owned by a hospital or health system. And you can see that back in 2018 even, more than half of all specialists were already owned or affiliated with a hospital or health system. So this is a concern in California as well. Next slide. And I want to say that, just point out that these price increases directly affect working class Americans. There's data that's showing that increases in hospital prices are past 1-to-1, dollar for dollar, to increases in premiums. And that because insurance, the cost of medical insurance is roughly the same, whether you work in the mailroom or are the CEO, this increase in premiums essentially serves as a head tax, so that lower income Americans, those making between $20,000 and $100,000, have seen decreased employment due to these rising healthcare costs. The graph on the right shows you the percentage of healthcare premiums that go towards, the percentage of income that goes towards healthcare premiums. And you can see that over the past few decades, it's really affected lower income Americans. A recent economic paper by Brott Goldberg estimated that a hospital merger that raises prices by 5%, so that's a pretty average hospital merger from the last slide, results in $32 million in lost wages and 203 job losses in the county. Next slide. So one of the key tools to mitigating this market power is antitrust oversight. So at the federal level, I'm sure you're all aware of this, so I'm not going to go into the details, but there's been a lot of increased attention at the federal level. And many states, including California, have adopted new laws that increase oversight of healthcare mergers specifically. In California, this is the Office of Healthcare Affordability, which does take in material change notices of many transactions and does writes a public report about them before they occur. Next slide. But in many markets, especially in healthcare, it's too little too late. Next slide. The train has left the station. So this slide is from data that just came out a little over a week ago that showed that 97% of metropolitan areas had concentrations that met the FTC and DOJ levels of highly concentrated. So by measure of HHI, which is the square of the market shares, all three of the dark blue here would be considered highly concentrated by the new merger guideline thresholds. I apologize that the color there isn't so obvious, but the only 3% of markets would be considered competitive or even moderately concentrated by these standards. Next slide. So this slide I often present to lots of states who are looking for options to address these high and rising prices. And certainly in the interest of time, I can't go into any detail about any of them here. But I would say that the states are really thinking about them in three buckets. So the first one is really strengthening oversight of consolidation and thinking about preventing harmful mergers before they happen. The second bucket is promoting competition and improving market function. And there are a whole lot of things that states are thinking about here. I'll just point out that one of them would be to add an abusive dominant standard for antitrust enforcement. Although there have been many cases filed against Sutter, for example, here in California, but also across the country, alleging anti-competitive conduct under existing antitrust laws. And finally, there are a number of states that are looking into addressing high prices directly and thinking about some form of rate setting. Next slide. And so just in conclusion, it's beyond a doubt, sort of the research evidence is extremely clear that consolidation has led to unaffordable increases in healthcare prices. Some experts, Bruce Vladeck and Uwe Reinhardt, who are sort of pillars of economists in this space, have actually called it a great transfer of wealth from workers and employers to the providers of healthcare services. Increases in these healthcare costs are disproportionately hurting low and middle income Americans, and that state and federal governments are working to increase merger oversight, but the impact may be minimal if all they're doing is preventing additional consolidation and harms. And so it's really important to find ways to address existing healthcare consolidation and market power. Thank you. That's the end of my comments.
Do the commissioners have any questions? Okay, thank you very much. We really appreciated your presentation.
Thank you.
Next up, we have Michelle Rivas from the California Pharmaceutical Pharmacists Association. I'm sorry, I'm getting it wrong. You can correct me, Michelle. And she is obviously in person. We very much appreciate you being here, and you may begin.
Thank you. Happy to be here. Appreciate the opportunity. So I will go past the first couple of slides because Dr. Feldman did explain what a PBM is. So if we could go to the next slide, please. The next slide. The next slide. So I'll start here. She did mention briefly about the vertical integration. This is one of the challenges that we're seeing with PBMs is, again, the vertical integration. I'll go into more details about what that means to community pharmacy and patients. So if you see here up on the graph, over the years, it has increased quite significantly. So this has definitely contributed, we believe, to the cost of medication and limiting the opportunity for patients to go to pharmacies that are not owned by a PBM. Next slide, please. This data is from 2019, so I can only imagine how much more the profits have increased for the PBMs, and you'll see this data shows you that, again, in that year, that the health plans profits were even higher than technology. And again, this was after vertical integration. What we do know is that when health plans and PBMs started integrating, the health plans' profit margins exploded. As you all know, the health plans are required to spend a certain amount of money on patient care, and they're limited to how much can go for profit. That is not the same for PBMs. So when they integrate it, again, it significantly increased the profits of the health plans. Next slide, please. So I'm going to talk a little bit about some of what we're seeing are problems with PBMs, and again, how it's affecting community pharmacy and patients. There's absolutely a lack of transparency with PBMs. We know that there have been employers who had to sue their PBMs for asking for information, talking about rebates. How much are they getting back from the drug manufacturers when they negotiate the rebates that determines whether or not a drug is placed on the formulary? There are, again, the price of the drug, the formulary, et cetera, and the employers, the health plans not being able to get this information. So if you can imagine contracting with somebody and asking them to provide you information to make sure you're getting what you paid for, and that person telling you no and not providing that, and that is something that happens routinely in this space. PBMs are not regulated in California. There are other states, and I'll get to that slide in a moment, where they are regulated. So they are not regulated at the federal level, and they're not regulated in California. We passed a bill a few years ago that requires PBMs to be registered with DMHC, but that is not the same as regulation, as you know. So the only thing that California knows is who the PBMs are doing business with, because they have to register that with DMHC, but they are not a regulated entity. Now, there is one line of business within the PBM space, that being mail order. That line of business is regulated, but again, the overall practice, PBMs are not licensed or regulated by the state of California. Next slide, please. So these are some of the business practices that we consider unfair business practices the PBMs are conducting, primarily here in California, since so many other states have passed laws that prohibit this. Spread pricing, and again, this is something that absolutely does affect patients. I had a conversation recently with an independent pharmacy who contracts with the skilled nursing facility. There was a patient whose health plan was being charged $50 for an anti-nausea medication. The PBM was reimbursing the pharmacist $15. The pharmacist's cost for the drug was $16. So the $50 was a lot for somebody to have to pay. So the administrator for the skilled nursing facility called the pharmacist, said, "Is there something we can do?" And the pharmacist said that the cost of this drug is only $15. Yet the health plan was charging the skilled nursing facility $50. So now that patient is paying out of pocket to get a much lower rate. That is what we refer to as spread pricing. They reimburse the health plan at a far lower rate than they're reimbursing the pharmacy, and they're keeping the spread. Next slide, please. These are some of the other unfair business practices, rebate pumping. We absolutely do believe that that is contributing to the high cost of medications. There again, definitely some need for transparency in this space. Rebate retention, them keeping those rebates, that being the PBMs and not passing them back to the payers, and clawbacks. Clawbacks is one of the business practices that is really hurting independent pharmacy. What the PBM will do is, after claims have been adjudicated, it could be as much as a year later, the PBM will come back to the community pharmacy. We're taking back $300,000. No explanation as to why. They just take back those monies. That is clawbacks. Again, another practice that we think needs to be addressed by the state of California. Next slide, please. And I know I'm speaking quickly. I just want to make sure I get to everything, so apologies for that. Reimbursement. Another problem here in California. We know that PBMs that own pharmacies, the one that everybody thinks of most often, it's Caremark/CVS. CVS is the pharmacy, Caremark is the PBM. The two other largest PBMs, that's Optum and Express Scripts. They own what they refer to as specialty pharmacy. And for the record, there's no such thing as a specialty pharmacy. It's just drugs that are expensive. They have their own specialty pharmacies. So what they're doing is reimbursing the pharmacies that they own at a higher rate than they reimburse the community pharmacy. So for example, and here is some information that we were able to collect. These are all obviously behavioral health medications. The pharmacies are being reimbursed incredibly below the pharmacist's cost of acquisition for the drugs. In some cases, as much as $1,200 for a drug. So what does that mean to a patient? It means that the pharmacy cannot afford to stock those medications. So when the patient goes in there for their drugs, pharmacy doesn't have them because you cannot keep your doors open if you are being reimbursed below the cost of acquisition. We are hearing a lot more often from physicians who work in behavioral health space saying, hey, my patients are having a difficult time getting their medication. What's going on with your members? And I have to explain to them, this is what's happening. It's not just in behavioral health medication. We're seeing it happen increasingly with HIV medications, where again, the pharmacy is being reimbursed so far below their cost of acquisition, they cannot stock those medications. It is just not sustainable. Next slide, please. Patient steering is another practice that the PBMs will use that is harmful to community pharmacy. So pharmacists, even though they're within a network, are being denied the ability to provide care to those patients. What the PBMs will do is that they will send the patient a letter that will say something like, your medication is no longer covered due to clinical necessity. So if I'm a patient and I'm looking at that letter, I'm going to think, okay, it's not clinically necessary. I must not need this drug anymore. Well, then they'll get a letter shortly after that that says, oh, your medication is covered, but you have to go to Pharmacy X. Well, guess what? The PBM owns Pharmacy X. Patients are also getting letters now that will tell them your pharmacy is no longer a network. You have to go to Pharmacy X. So the patient transfers all their drugs to Pharmacy X to later possibly getting a letter from the PBM that says, oops, it was a mistake. Your pharmacy is in the network. So that's what we refer to as patient steering, which again is another unfair business practice that is harming community pharmacy and it's hurting patients. When you're dealing with patients, especially those who have chronic illnesses, the relationship that they have with their healthcare providers is incredibly important. Their physician, if they need a specialist, and the pharmacy. And the providers work together. They communicate constantly to make sure that they're providing the adequate care to the patient. When that relationship is severed, it absolutely does harm patients. And when we see these things happening, especially if it's an independent pharmacy, independent pharmacies tend to be located in underserved areas. They tend to reflect the communities for which they're providing care. There are cultural competencies, there are language issues. And when, again, that relationship is severed, that patient suffers harm. So this is another practice, again, that we are hoping to see addressed at some point. Next slide, please. So California, we are not leading in this area. Next slide, please. These are some actions that other states have taken. And what's interesting about this issue is that it's not a secret. Republicans don't tend to like regulation. Deep red states are regulating PBMs now, and California is not. This is a bipartisan issue. All of the bills that have passed in other states have had broad bipartisan support. And again, even deep red states have taken a stance and started pushing back against the PBMs and addressing some of these unfair business practices.
I'm sorry, could I interrupt? What is your view of why California is not following Mississippi's lead? Is it money flow to people who make decisions, or is it something less crass?
Well, we did have a bill that we ran, Senate Bill 966, that would have addressed these issues, with the exception of it was amended the last couple of days of the session. Spread pricing was stricken from the bill, as was how PBMs are reimbursed. They charge a lot of fees to pharmacies, to drug manufacturers, et cetera. I mean, dozens of fees. We wanted to address that for a flat rate. And there are PBMs that function that way, and they function quite well. They're providing a service and they're still making money. But the three big PBMs don't tend to operate that way. So again, we had a piece of legislation, got it through the legislature. I think we had a total of 2 no votes. That was 4 policy committees, 2 fiscal committees, 3 floor votes, and only 2 people voted no, and 9 assembly members laid off when the bill was on 3rd reading on the floor. But the governor did veto the bill. So we'll be meeting with the administration to see what we can do to address any concerns that the administration may have. So in hopes of moving something next year.
And what did the governor's veto message say?
The governor's veto message noted that he would like more granular data. Our bill did have a requirement for transparency because the information just isn't out there. Again, we ran a bill many years ago. I think it was in 2018, the Assembly Member Wood carried. And one of the things that that bill required was that DMHC form a task force to study the issue. And what they said is that we need more information because right now it's just not available. So all of their findings we placed in Senate Bill 966, which again would have provided some transparency so the state would have the type of data that policymakers know to really get a grasp on what's happening. We all talk about drug prices and, you know, the drug manufacturers are already required to provide a lot of information to the state of California, but until the PBMs have that same responsibility, we're never going to fully understand why the cost of medication continues to rise. So that was one of the messages in the veto was the need for more granular data and questioned the licensing structure. We did ask that the PBMs be licensed and regulated by the Department of Insurance. So we will be having some conversations, hopefully in the not too distant future with the administration in hopes of moving something soon. Because I'll talk about this a little bit, but time is not on our side for this issue. But again, I'll touch on that in the next couple of slides.
Thank you.
Thank you for the questions. I appreciate it. Next slide, please. So here are the 25 other states that have moved legislation in our bill. We picked out pieces from various states that we thought were the strongest. So a lot of what we tried to do in California came from other states. Next slide, please. So there is a lot of activity at the federal level. I hope that someday Congress can actually move some real reform, but there are several bills being discussed. The FTC has taken an interest in this, and it was interesting because several years ago, they issued a report that seemingly supported the PBM's position. But then they pulled that report back and the PBMs were still using that old FTC report when they were lobbying against other bills in the states and the country requiring that they be regulated. So the FTC actually issued a statement saying, quit doing that. You're citing old information. We have learned more. Those statements are no longer accurate. Stop using it. So the FTC, next slide, please, did issue a report recently. So these were some of their findings. And this report came out, I don't know, probably about 3 weeks, I think, before the end of session. So we were quite pleased because everything that we had been arguing was substantiated by this report from the FTC. Next slide, please. So what does all this mean to community pharmacy and patients? This is some data that we pulled the last couple of weeks that shows 411 pharmacies in California alone have closed since December of 2023. This is not just an independent pharmacy issue. And historically, when we talked about PBMs and their unfair business practices, we have focused on independent pharmacy. But what we know now is that this is affecting corporate chains. So when we ran our bill this year, NACDS, which is the national group that represents chain pharmacies, they were lock and step with us and supporting the legislation, with the exception of CVS. They're not a member of NACDS, so they were the only corporate chain that was opposing our bill. Because again, these business practices are affecting all of community pharmacy with that one exception. So these numbers again reflect independent and corporate chains. And again, this is a lot, which is why I mean, I think a lot of people up here worked on legislation, and it's always tough when you get a veto. Nobody likes getting a veto. But when we look at these numbers and see the rate of closures, it's alarming. And while we were working through this bill, the opposition kept saying it's too soon. We need more data. We need more data. Well, y'all have the data. Why don't you just give it to the legislature? But that wasn't going to happen. And we've been arguing we do not have the luxury of time. This is a problem, and it's a real problem.
Ms. Rivas, are there pending litigation lawsuits against PBMs on this particular issue?
There are in fact, there is, right now, pharmacies have no recourse, none, other than to litigate, which has got awful expensive. Can you imagine suing a corporation that makes tens of billions of dollars in profit?
I'm a trial attorney. I can.
There you go. So,
Yes.
okay, so you know,
Mhm.
I'm not a lawyer, but you know. So
Yes.
there is a pharmacist, Maria Lopez. She owns Mission Wellness in San Francisco. She sued her PBM and she won, but they are still fighting her. It was $1 million in settlement that they owed her. And so she's now having to fight them to get them to pay. And the last figure I heard, it was $1.5 million in attorney fees to her. This is a woman who worked her way up. She did not grow up wealthy. She has given everything to her pharmacy. She provides a tremendous amount of care to most of her patients have HIV. And this entity is destroying her business. And I can't share her whole story because it's not my story to share, but what I can say is that I know what a huge personal sacrifice it was for her to be able to hire a good attorney and to go after them, and she's still fighting them. So that's one case that I'm intimately aware of because I know Dr. Lopez and I love her and work together constantly. But there are two other groups of patients who have sued PBMs. CPHA and the LGBTQ plus community have worked very closely on this issue. They were actually probably the first ones who started challenging PBMs. So there's two groups of individuals who are HIV positive who have sued their PBMs, and it was really around patient steering because they were forcing them to use mail order. Well, not everybody who has HIV, their status is known. Unfortunately, there is still a stigma around that. So their medications are at their doorstep. We all know things get stolen. Well, now their information has been compromised. So these two groups again have sued. I do believe that one of the groups settled, and I can follow up if you'd like. I can look back and get the information to you. But those are the two groups that I'm aware of. And it's my understanding there's another group of pharmacists who are now in the process of also suing a PBM. But as you well know, it's not something that most people can afford to do.
We'd be happy to follow up with you. Staff would be happy to follow up with you to get that information for our commissioners. Thank you.
Great. So again, the impact whenever a pharmacy closes and the Mission District, again in San Francisco, anybody who's been there, it's a very densely populated community that's been identified now as a pharmacy desert. When people think of pharmacy deserts, you think of really rural areas. That's not necessarily the case. It's happening in the urban areas as well. And again, the reason there are other factors, and I don't want to be unfair about that, but from what we're seeing from our members and the type of information that they provided to us, the number one reason that these pharmacies are closing is because of these unfair business practices. You know, you figure they're under reimbursing them for the drugs significantly. They're forcing their patients to go to other pharmacies, and then they're coming back later and saying, oh, we're going to take even more money from you. How do you keep your doors open? You can't. I have members right now who are not paying themselves salaries. They were hoping our bill was going to be successful. That's the hope that they were holding on to. Not paying themselves, having to lay off staff, having to take out personal loans just to keep their doors open because they're concerned, where are my patients going to go? So it's a real problem, and we're really hopeful that California sooner rather than later will recognize that, because if we don't, this is an area that is going to be, and lawyer on the room, I probably shouldn't use this word, but it's becoming a monopoly. And I don't think any of us want to have to rely on a for-profit corporation for our healthcare. And that's what's happening because community pharmacies are closing. So thank you I'm sorry, I can carry on forever about this issue. Next slide, please. So happy to answer any more questions that anyone may have.
Do we have any questions?
No, we've asked them all.
Okay, thank you so much for your presentation. And
Thank you.
for our final presentation, on behalf of the Motion Pictures Association, we have Dan Robbins and Aaron Mergadishian. And they are here in person and will be stepping up. And my understanding is that they do not have slides. So we look forward to your presentation. Thank you.
Do they have name cards?
Well, thanks for allowing us to come and share some thoughts with you. My name is Dan Robbins. I'm the Senior Vice President and Associate General Counsel at the Motion Picture Association. The association represents the interests of producers and distributors of motion pictures and television programming. One of my jobs at the company, which operates in over 100 different countries, is the Global Antitrust Compliance Officer. I'll let Aaron introduce himself.
Oh, thank you. My name's Aaron Megardichian. I'm an Executive Vice President at Compass Lexicon, which is an economic consulting firm. Prior to joining Compass Lexicon, I was a lecturer at the University of California, San Diego, and also the business school at San Diego State University. I'm not a lawyer. I hold a PhD in economics. I'm an economist.
Great, thanks. So we sent in last Thursday a 10-page letter that I wrote about legal issues and a 50-page economic study that Aaron wrote about the economics of the sector. And I'm going to speak briefly about the legal piece and then yield the floor to Aaron on the economics. I think before I start, one thing after listening to all this today, I think something that's critical for you to keep in mind is the antitrust laws are laws of general applicability. So we may have problems in healthcare, we may have problems in the pharmacy sector, we may have problems with AI or big tech, but if you draft an antitrust change, it applies to everybody. So you have to think about all the others as well, unless of course you're going to do some narrowly tailored bill as the last speaker suggested in her sector. So something to keep in mind. Just three quick points. So on mergers and acquisitions, our state does a nice job with the Clayton Act, the federal law. We can enforce it, and we do. The AG's taken cases to the United States Supreme Court and won unanimous decisions, even in situations where the FTC had already approved the merger. We went in, I was a law student there working at the time, but the AG went in and got the right result for the state. In 2022, we passed a merger law in the healthcare sector, as was mentioned by others. In 2023, we followed that up with in the grocery and pharmacy sector. So we've been active in passing lots of sector-specific bills. It's the MPA's view that we don't need a general change. We don't need to change the Clayton Act. That would create differences at the state level from the federal level. We don't need, for example, the New York bill and the bill in Maryland provided that any transaction, so for example, New York, any transaction over 9.2 million had to be reported to the AG. That's
it's a drastic additional amount of work for the AG's office. It doesn't result in any great impact on competition. It creates a lot of burdens. I can give you an example from my sector if you're interested. When we're done, I have a good one that's sort of an unintended consequence. We're not unreasonable, though. We do support the Uniform Law Commission's Antitrust Pre-Merger Notification Act. We think that solves a real problem today and would recommend that. Monopolization quickly. The MPA agrees with your expert group, the New York City Bar and the American Bar Association, that the New York bill you've been asked to consider is fatally flawed. It has a lot of unintended consequences. The MPA has opposed it successfully in New York 4 years in a row, and we would oppose it if it came here. I'll just give you one example. Someone mentioned earlier, this has a 40% threshold. That's partially true. That's on the outbound side. If you're bringing something in, it's actually 30%. So if I go to a small town, I shoot a movie, I use more than 30% of the caterers, writers, actors, directors, what have you, I'm presumed a monopolist for shooting one movie in one town for 1 month. That's a good example of unintended consequences. I don't think that's what the author wanted to get at, but the law applies to everybody. So it would, be discourage that kind of activity. Also, we oppose the single firm working group's 3.5-page recommendation. We think it's ambiguous. We think it throws out a lot of great law that we've had since the 40s. And you've heard a lot about the Supreme Court rulings, and some of them are controversial. But this suggestion is to throw out things like relevant market and market share. We've used since the 40s. It's not a Roberts Conservative Court idea. It was expressly endorsed by our most liberal Supreme Court, the Warren Court. We've had it for a long time. We know how to use it. It works. We think throwing all that aside and doing something completely new is going to create a lot of uncertainty for the state and a lot of litigation. That's probably your most controversial proposal. You're going to hear from a lot of folks on that. Having said all that, we're not unreasonable. We're glad to talk about other options in that space. And then finally, before I monopolize Aaron's time, the concentration report, we're sort of an afterthought in that report. We got 4 paragraphs. We didn't think it was objective or empirical with respect to our sector, which is why I hired Aaron to come in and give you some empirical analysis of what's going on in our sector. I just give you a quick example. It mentions there's 6 companies that control the media. The evidence for that is a 2016 blog post from a marketing firm. A paragraph or 2 later talks about 3 giant corporations that control entertainment. But what it doesn't mention is the leading streaming service in the United States is YouTube. It's not any of the companies that are mentioned. It doesn't mention the new entrants. Amazon has come in and made a lot of good content. It's a significant competitor. Apple's come in. You've all seen probably some of their content. They've got some great stuff. And then we've got a strong independent sector, legendary Lionsgate, tons of other companies that have won lots of Academy Awards, and they're significant too. So having said all that, I'll turn it over to Aaron to talk more about what's in our economic report and help try to give you a better sense of what our sector looks like.
Yeah, so my report dated October 3rd assesses the competitive health of the audiovisual industry. And so by that, I mean the production and distribution of motion pictures, television shows, social video, and other audiovisual content. So let me start with the main takeaway on the consumer side is that my report presents a lot of empirical evidence to suggest that the audiovisual industry is dynamic and highly competitive. First, over the past decade, there's been a significant technological advance, and that's driven substantial changes in how content is produced, who's producing it, and how consumers are receiving that content. We've seen entry from the likes of Netflix and Amazon Studios and Apple, and they're creating both, full-length motion pictures as well as multi-episode streaming TV shows, right? And, one example is Ted Lasso, which I think everyone loves, and also Martin Scorsese's Killers of the Flower Moon, which came out a few years back, which was both commercially very successful and got a lot of critical acclaim. There's hundreds of services now in additional to the traditional services. So the traditional services are cable, satellite, and over-the-air broadcast. It's just not the names that we all know, like Netflix and Paramount and Amazon and Apple TV and Hulu and so on. I mean, there's literally 200 of them, which is documented in my report. But it's also, smaller niche providers like Crunchyroll, which provides content related to Japanese anime, if that's what people like, or Faith Life TV, which is a streaming service that's, geared towards more religious content. And the other big provider of audiovisual content these days are the social media services. So you've got Facebook, Instagram, and TikTok, and to some degree also YouTube you can think of as a social media service, but they're pretty much now on top. And, for a large part of consumers, YouTube is free when you watch it with advertising. Indeed, the landscape has changed significantly. In the most recent year, we had data. The streaming services are spending about $40 billion investing in content, whether it's the content that they produce or whether they acquire it through licenses. Households now have roughly 4 online subscriptions on average. The growth has largely displaced traditional distribution channels like cable and satellite, as well as physical DVD and Blu-rays, just as those technologies, displaced VHS 25 years ago. Entry and dramatic growth of these new over-the-top services that compete for consumers. I mean, this is exactly what I would expect to see in a highly dynamic and competitive industry. And it doesn't stop there. I mean, in my report, I show empirical evidence. The amount of content and the variety of content has increased over time. The number of film and TV sites available to consumers has never been greater. Up until COVID, the number of films released each year had been steadily growing, and then COVID happened, and so there was a shutdown in the industry. The audiovisual quality has increased over time, either through things like 4K content. There's advanced sound processing. There's improved user interfaces. There's other things like algorithms that these different content providers use to get the type of content that people want to consumers quickly. And these are all investments that the industry has made to bring better viewing experiences to consumers. And pricing in the industry is also consistent with what I expect to see in a highly dynamic and competitive industry. In fact, multiple streaming services are completely free to consumers. So these examples are Pluto TV, Tubi, and also YouTube. And then even Netflix, they have packages for as low as $6.99 a month for consumers. So to me, it's not surprising that consumers are so-called cutting the cord with their traditional cable and satellite providers and flocking to these new innovative services. And let me talk a little bit before my time is up with respect to the labor side of things. So this shift in audiovisual content production and consumption towards new over-the-top distribution services, this has sort of helped lower barriers to entry for talent to reach consumer audiences. In addition, strong unionization in the audiovisual industry, namely collective bargaining by numerous guilds and unions helps to create favorable outcomes for workers. As I showed in my report, the empirical evidence demonstrates that the labor market is well functioning. Direct employment in the audio visual industry in the US has been steady since at least 2016, with the exception of the shutdowns during COVID. But even since then, we've seen a pretty good bounce back. There's been some decline in employment in California specifically, but this is largely due to production leaving the state for lower cost states and other countries. The audiovisual industry wages in the US and in California have increased over time, even when adjusting for inflation. And both the level and the growth rate of wages are above the all other industry average in both California and the US. So in other words, the audiovisual industry is paying more on average, and it's increased over time. So I'll just conclude by saying, just to recap, the empirical evidence in my report, all 50 pages of it, which I'm sure you'll read over the weekend, supports the conclusion that the audiovisual industry is dynamic and highly competitive, has numerous participants providing an increasingly diverse array of content across new and innovative delivery platforms. And all of this, gives consumers a lot of benefits. And finally, the empirical evidence that I analyzed demonstrates that the audiovisual labor market is an important employer in California, and it's a well-functioning labor market.
Mr. Robbins, you gave an example of a smaller film reaching that 30% mark. What would you say would be a practical solution to that if you were the body that was trying to recommend a kind of solution, right? A legal solution? Would it be a cap on the amount of money of the budget? Would it, how would you practically address those in legislation?
Yeah, no, it's a good question. I think one thing I would do is I would add a temporal element. So I think it's one thing to go to a small town, use 30% of the resources for a month and leave. That to me shouldn't be a felony, which is what it was in the original New York bill. What we're trying to get at here is the exercise of long-term market power. So we're talking this, just in my mind, of like somebody who's got 70% of the market and has it for a couple of years. They've demonstrated that they're powerful. They're not going anywhere. It's not something that happens in a month. So I think you need a clear temporal element. And then the other thing is, some type of, appropriate market share. The word we've always used is monopolization, mono, one. With 30%, you could have three. And that's not, I don't think that's what we're getting at. We're trying to get at somebody whose power isn't checked in some kind of meaningful way. So I would add a temporal element, and 30% is way too low. Like under our current law, there have been no convictions for anyone under 75%. I'm not saying that's the magic number, but you want something where you're looking at somebody who's demonstrated power over a number of years in the market.
Thank you.
Yeah, the letter you sent us talked about potentially a conflict between antitrust law and the Copyright Act. Is that something that's been litigated?
Yes. So at the federal level, the intellectual property laws and the antitrust laws sort of live in balance. One gives you a lawful monopoly for a certain period of time, and the other seeks to restrict unlawful monopoly, but they're both federal laws, so they're on equal footing. That's not true of state laws. State antitrust law is generally not preempted by federal antitrust law, but it can be preempted, for example, by the Copyright Act that has in section 301 expressly prohibits contrary state law. In the case of Orson versus Miramax, which was a Third Circuit en banc decision, what happened is Pennsylvania decided to restrict how long a studio could have a theatrical license for an exhibitor. Basically, Pennsylvania said, okay, you can license exclusively to one exhibitor for 42 days, but then you have to give your movie to anybody else who wants it. And so Miramax brought a case against that saying, no, I have these exclusive rights under copyright. If I just want to license my copyright to one entity for an extended period of time, copyright law permits that. And the Third Circuit in an en banc ruling, which means all 15 judges in the whole circuit participated, ruled that the Pennsylvania statute was unconstitutional and preempted. So this comes up. You often hear about, oh, well, we don't like exclusive contracts or exclusive licenses, and there's a lot of focus on that as a negative form of conduct that a monopolist might engage in. But for an individual holder of a copyright, it's expressly permitted in the Copyright Act that you can do something like that. And so that's why the Pennsylvania law was thrown out. That's the best example I can think of.
Okay, that helps. Thank you.
And could I add one more example? Sure. Thank you. I skipped over this earlier because of time, but it's been suggested maybe we have a merger law that has a lower threshold. So the federal threshold is about 120 million. It's meant to capture significant deals because those are the ones that can have harmful competitive impact, both in New York and Maryland. They lowered that quite a bit. And so what happens is, I'll just give you an example. So it's common for movie producers to go to book authors and make an exclusive deal with them. Like, I want to license Harry Potter from you. And I'm going to pay you this amount of money, or Lord of the Rings, or lots of other books. And those are exclusive licenses. And under the New York bill, those had to be reported. And so for us, the problem with something like that is, if I'm paying more than $9 million, which is quite common for, good books, almost all the time over 10, then all of a sudden I've got to go to Albany and get the AG's permission to make the movie. You could easily imagine if that weren't 50 states, there's movies you could make in California that wouldn't be so popular with the Texas AG. But we still have to get that person's permission. It just creates all sorts of different complications and transactions costs that really don't help improve competition. So that was the other example I had in mind. Thank you for listening to that.
Oh, then the next portion of the antitrust agenda is public comment. So if there are any folks in the room who would like to make a public comment, please step forward. If you are joining us via the webinar, please raise your hand so that we can recognize you. Looks like we do have some folks. We have 3.
And we have, before we do that, we've neglected to thank our latest 2 speakers. Mr. Robbins, it's always good to see you. Thank you both for your time and attendance today.
Sorry about that. Yes, thank you. My omission. Okay, so Sarah, you say that we have 3 people in the queue. It looks like we do not have anyone in the room. So I will hand it over to you. We are limiting you to no more than 5 minutes to make your public comment. And we very much appreciate you joining us. Thank you.
Bryn O'Neill, you have your time is available.
Thank you. Good afternoon. I'm Bryn O'Neill, a regulatory policy specialist with the California Nurses Association / National Nurses United, which is the largest union of registered nurses in the state, representing over 100,000 RNs across California. And I wanted to talk about the AI portion of the discussion. So thank you to the Commission for having this important conversation. Similar to anti-competitive uses of AI in housing and other areas, employers and healthcare corporations can use AI in ways that abuse or maintain their dominant position in the labor market and healthcare markets, harming both workers and patients as a result. In labor markets, large employers are increasingly using AI tools and various digital labor platforms, creating application-based or gig-based work to manage hiring, staffing, scheduling, and setting wages or payment rates for workers. Often these app-based work platforms misclassify workers as independent contractors, which deprives workers from employment and labor law protections. Without protections from these abuses, app-based tools in the workplace can enable employers to fix wages and prices paid to workers for services and otherwise dictate terms and conditions of employment. Even worse, AI staffing tools used by large employers can result in the replacement of workers with AI tools as employers attempt to further automate work. The first examples of algorithmic technologies in the workplace that may come to mind are rideshare and food delivery applications. But gig-based work platforms are proliferating in many industries, including healthcare. In healthcare and nursing, as partnerships and vertical integration of tech companies and healthcare corporations have rapidly grown, so has the use of gig work platforms. Some nursing-based staffing apps include Clipboard and ShiftKey and are even promoted as Uber for nurses. Big tech is also partnering with big healthcare, which can lead to harm for both healthcare workers and their patients. For example, NVIDIA, one of the largest chip manufacturers in the world, has partnered with Hippocratic AI and are pushing healthcare providers to use its generative AI virtual healthcare agent, advertised as a $9 per hour nurse. Electronic health record systems, which are ubiquitous in healthcare, like Epic, for example, are increasingly integrating ambient AI surveillance tools and other clinical decision-making algorithms into healthcare data systems, raising privacy issues for patients and patient safety concerns. Acquisitions between healthcare systems and tech companies, like Amazon's acquisition of One Medical, should also be a concern for antitrust regulators, particularly with respect to healthcare reimbursement rates and patient data privacy. Antitrust regulators should be able to scrutinize AI tools that may be used by healthcare conglomerates to steer healthcare markets to their own advantage. These examples are just the tip of the iceberg on how AI can be used in anti-competitive manners by employers and healthcare companies. We urge the Commission to consider ways to address these potential anti-competitive behaviors as you consider antitrust reform. Thank you.
So my understanding is that we have 3 more people in the queue for public comment. Please queue up the next person. Thank you.
Terry Ollie.
Good afternoon, Commissioners. Terry Ollie with
Did we lose Terry?
Nope, hear me?
Terry, you're back.
Oh, great. Thank you so much. Good afternoon, Commissioners. Sorry about that. Terry Ollie with Economic
Terry,
Security.
if you could just speak up a little more. Thank you.
Okay, can you hear me?
Yes.
Is that all right? Okay, great. Thank you. Good afternoon, Commissioners. Sorry for the false start. Terry Ollie with Economic Security California Action. Really appreciate the depth and the breadth of the work that you all are doing today. I know it's been a long day, so I'll keep this brief. As someone who has spent much of the last year working to pass legislation that would impose very light touch, common sense regulation on the behavior of large frontier AI models to protect us all against potential catastrophic harms, and seeing how challenging that was, I am acutely aware of what is happening in the AI industry with respect to corporate concentration and how that translates into power that puts big tech companies in the driver's seat and increasingly minimizes the ability of policymakers to have any say over the future of this area of the economy. I really appreciate the working group's report today, and I want to just highlight a couple of things that I saw in there and lifting up some of the comments that were made already today. I really see the area falling into two, or this issue falling into two buckets. The first thing is the ways in which AI is used to carry out sort of antitrust behavior that, if done by a human, would be would definitely fall already into our antitrust rubric and to cause harm. And the previous caller spoke about that, but algorithmic collusion is something that has come up with RealPage, and we're seeing this in other places as well. And I really want to lift up how much we agree with the recommendations in the working group report to recognize that when machines do the work, if you will, that humans would not be allowed to do, that we need to treat it the same. So I really want to appreciate you recognizing that. And also just want to call out that we believe that should have nothing to do whether data is public or private. When you have collusion, it's collusion. And that is a really important policy to make sure that we're advancing. Second, I want to talk a little bit about some of the structural issues that Professor Netarenia spoke about today and that we've seen in other places. And that is looking at how we just overall consider how concentration is accelerated by AI and by the resource intensiveness of this economic sector. And just put forward and kind of, I guess, reinforce what the professor was talking about with respect to really thinking about the more structural reforms that we need, including things that already are in our toolkit, like pre-merger notification, but also going farther to think about ownership structures in the way that we've looked at other industries in the past, like railroads, like the banking industry, and really think about, should there be just restraints and constraints on the ability of corporations to have so much ownership within the vertical stack, if you will, of the AI sector, such that there really is no competition, and it may look like competition, but there really isn't any. And some parts of that could include restraints on ownership. There could also be requirements around interoperability, no egress fees, et cetera, non-discrimination and fair pricing, and the like. I just want to point out that I think those are really important things for the Commission to consider as structural changes that we just really haven't discussed it in great enough length. And then finally, I want to call out how and appreciate in the working group's report that the need for something like a digital regulator. Again, spending the last year really looking at the AI sector, it is quite evident that we have very, very little regulation on tech and on the tech industry. Every other industry has some sort of, body, if you will, that and again a regulatory architecture that we use to look at the way that industry is behaving and how it's intersecting with people in the world. And there just really isn't anything like that for tech. And so while that's an idea that obviously needs a lot more thinking, and we want to make sure to draw from good positive models and not get ourselves into a 20-year process necessarily. I think that's something we really need to explore further and think about how we appropriately regulate this sector that has certainly been around for several decades, but has really accelerated in the last couple of years with AI and has started to pose real threats of competition in a way that chokes off this market in a way that none of us want. We all want a flourishing, competitive AI sector and a flourishing, competitive tech economy. So with that, I'll close, and I really appreciate the work that you've done here today.
Thank you. I believe that we have two more people in the queue. If you could please tee up the next person.
Thank you. Angel Lynn.
Good afternoon, commissioners. My name is Angel Lynn, and I'm grateful for the opportunity to provide a comment on behalf of the Green Mining Institute. Our organization's mission is to create a future where communities of color can thrive and build wealth. And in order for these communities of color to thrive, it's imperative that the Commission considers the intersection between market concentration, AI collusion, and other anti-competitive practices with respect to this intersection's potential to extend discriminatory impacts onto communities of color. Algorithmic pricing tools developed by companies like RealPage and highlighted throughout the report and other speakers today are the newest iteration of predatory anti-consumer practices. In one neighborhood, the prices for 70% of the apartments were set by RealPage software, allowing for property managers to collude to artificially raise rent prices. But in a state where 48% of our renters are Black or Latino, Algorithmic price fixing has potentially disastrous effects on these communities' abilities to find stable and affordable housing. Today's speakers also made it apparent that this issue isn't limited to rental housing. We want to call attention to the ways that these practices also extend to insurance and banking, sectors where algorithmic bias and market concentration also come together to harm consumers of color. In the auto industry, for example, algorithms charge higher premiums based on zip code or credit score, a criteria that disproportionately impacts Black and Latino drivers. And if we turn to home insurance, the class action lawsuit against State Farm alleges that the firm uses an algorithm that discriminates against Black policyholders. In banking, the reliance on algorithms to determine loan eligibility means that communities of color are unfairly penalized with higher interest rates and home mortgage loan denials compared to white borrowers with the same credit histories. Research shows that this type of pricing discrimination is tied in part to the lack of choice in the markets. And as insurers leave California and as banks consolidate and merge, consumers of color have fewer options, losing the power to vote with their feet and go to competitors that treat them fairly. We believe that our housing, banking, and insurance regulators have a role in minimizing algorithmic bias, and that the Commission should support that work by taking action to strengthen our antitrust policies and consumer protections. We support the recommendations in the report regarding the clarification and update of the Quiet Right Act. These clarifications are necessary to ensure that competitors who are using the same pricing algorithms are held accountable for what amounts to collusion, even if they never communicate directly. This means greater transparency and restrictions on the sharing of competitively sensitive data among market competitors. This also means that the DOJ's antitrust law section and other appropriate regulators should have the authority and direction to audit, track, and prevent these tools' negative outcomes, particularly on consumers of color. Thank you for your time, and I urge the Commission to adopt these recommendations to protect Californians from anti-competitive and anti-consumer behaviors facilitated by the use of AI. Thank you.
Thank you. And I believe we have one more person in the queue.
Yes.
Yes, Megan Abell.
Yes, thank you. Thank you for taking up this important issue of AI. Oh, can you guys hear me?
Oh, yes, sorry about that.
Oh, okay. I'm Megan Abel. I'm the Senior Director of Advocacy at Tech Equity Action. Tech Equity is a research and policy advocacy organization focused on economic equity issues that result from the tech industry's products and practices. We work to ensure that tech is held accountable for the harms that it creates in our communities and advocate for policy change through our guiding policy principles for responsible AI to ensure that tech's evolution supports human flourishing rather than undermining it. I'm really heartened that the Commission has taken up a report to address AI directly, as this technology is increasingly impacting workers, renters, and the public. While the prevalence of AI in our lives may be somewhat new, the issue of concentration and consolidation within the tech industry is nothing new. We're particularly glad to see that the report addresses the issue of algorithmic price fixing and collusion, and that the use of technology to control the housing market is addressed, an issue that Tech Equity has researched through our Tech Bias and Housing Initiative extensively. Increasing corporate dominance within the housing sector and private equity's entry into the housing market amidst the 2008 foreclosure crisis is really well documented. But the role of corporate interest in deciding everything from what your rent is to who lives where, and the use of technology to do this, is an underanalyzed and critical aspect of why our housing crisis persists. Technology-backed products have entered the housing system with the power to scale discrimination at a rapid pace. Importantly, this happens out of view by affected renters. Recent original research from Tech Equity revealed that just 3% of the more than 1,000 California renters that we surveyed received information on which companies were involved in their rental experiences. That same research revealed that 2/3 of landlords use some form of technology in the rental process. Intervention is needed to counterbalance corporate control of the housing system and the use of tech to achieve that control. The industry behind these tools are often called property tech or prop tech. and they received nearly $12 billion in investment in 2023. PropTech is everywhere, and any effective plan for the housing crisis must address industry influence and control of the housing market through technology. We agree with the report's recommendation in addressing algorithmic collusion. Where we depart from the working group is in one significant respect. Collusive price fixing schemes should be prohibited whether the data used to train them is public or non-public. Firstly, price fixing schemes can exist regardless of whether the data they are trained on is public or non-public. Second, nothing in existing laws prohibit price fixing, distinguish between public and non-public data. And third, predictating the existence of an illegal price fixing scheme on the sharing of non-public data opens up complicated drafting issues and unnecessary legal disputes over whether the data was accessible to the public, particularly given the shifting technology and legal policy attitudes over the proper custodianship of data. Thank you for considering this important topic and the opportunity to provide comment today.
Thank you.
Well done.
Yes, I think this concludes our antitrust agenda, unless the commissioners have any further questions or comments.
A comment, but for commissioners, we're now at the end of an extensive process of educating ourselves, and we need to start thinking about where we go from here. I would draw everyone's attention back to Memorandum 46, which articulates that under ACR 95, we were directed by the legislature to study and report back on 3 specific topics. And we need to really think about those over the holidays. It's a wonderful way to spend New Year's Day. Number 1, whether the law should be revised to outlaw monopolies by single companies. Number 1. Number 2, whether the law should be revised in the context of tech companies so that analysis of antitrust injury in that setting reflects competitive benefits such as innovation and permitting the personal freedom of individuals to start their own businesses, and not solely whether such monopolies act to raise prices. So those 2 are very specific. Number 3 is the catch-all, whether the law should be revised in any other fashion, such as approvals for mergers and acquisitions and any limitation of existing statutory exemptions to the state's antitrust laws. So we actually have a good roadmap on 2 very specific and 1 semi-specific things that we're going to need to do as part of whatever we end up doing. Okay?
Okay.
Thank you, Commissioner.
Thank you. Our last agenda item relates to, where did it go? State and local agency access to customer information, notice of administrative subpoenas. This is Sarah's item. So Sarah, if you could present, it doesn't actually, we're looking for commissioner feedback. So she will present it and ask for feedback. Thank you.
Thank you. Good afternoon. I'm presenting Memorandum 2024-48 related to the Notice of Administrative Subpoena. This memo just presents an update and proposed next steps. Just to highlight what was in the memo, we met with representatives from the Attorney General's office to discuss their concerns with AB 522, which of course was the bill from the last session that implemented the Commission's prior recommendation. In addition to their feedback, staff performed additional research, and we don't believe there's sufficient justification to limit the bill to natural persons, as the Attorney General's office has suggested. There is some merit, however, to their contention that a service provider may be able to more easily reach a customer to provide notice of a subpoena served on that provider. And the draft in this memo places the notice responsibility on the service provider. However, with the additional revisions to the way notice may be provided, easing the overall burden, I suspect stakeholders may take issue with this shift going forward. This draft also contains the other additional proposed changes described on pages 5 and 6. And I'm continuing to reach out for public comments that will likely present additional decision points and revisions for the commission at the next meeting. Does the commission have any questions about or concerns with this approach?
Any questions? So what we're looking for is a motion, correct?
Not at the moment, actually.
Oh,
So,
but you would like our approval informally to proceed with the approach you're outlining. you've
Correct.
outlined, But you don't need a motion.
I don't believe so.
Everyone looks happy, so you are free to, it is approved informally.
Thank you very much.
Thank you for the update. I think we're ready for a motion to adjourn.
Is there any other business before the commission?
I would like to mention, we do have a, thank you so much. I would like to mention that we do have a brand new schedule that has been adopted by the commission. We previously canceled the December meeting. It is currently listed on our website. However, that will be removed and the new adopted schedule will be updated and available to the public. So if you saw the December meeting, please do not come here. We want you to participate. We don't want to burn that bridge by having you here and not being able to hear your thoughts. And we will see you next year.
Yes, and as if you weren't here at the beginning, there will be a new chair. I have been overthrown by the peasants. Because we are in a mixed meeting, we need to call the roll. Is there a motion to adjourn? Is there a second? Please call the roll.
So I will call the roll of the remaining commissioners. Commissioner Ray?
Aye.
Commissioner Simpson?
Aye.
Commissioner Kubus?
Aye.
Commissioner Carrion?
Aye.
And Commissioner Hebner, chair, former chair almost.
I'm always annoyed by this unanimity. I'm tempted to vote nay, but aye. The meeting of the commission is adjourned.
Thank you.